Delivery of order, item number 1.
For reasons mentioned in the order, this bail application is dismissed.
May I read that order?
You will read it in the evening. It will be uploaded.
May it please, your worship. With consent of the other side, my lord, I beg to mention item number 5. Matter will be taken on Friday.
Item number
5.
heard. What is your name?
JC Gogol.
Heard me. You have heard Mr. J.C. Gogoi, learned counsel for the petitioner, who prays for an adjournment. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment. Hence, who does not have any objection to the same. Hence, hence the prayer is allowed. Let this matter be listed
Friday.
15th of June.
Lordship, item number 18, Lordship. There was a direction to do the TCR. And as per office note, the TCR is not received, Lordship. So, may I prefer listing this matter?
Wait for your turn.
Lordship.
We'll pass orders when the matter is called.
Lordship.
Wait for your turn.
Sir, that you mentioned item 9, my lord. Maybe we've taken up some other day. I've taken the concept of the other side.
Heard Mr. A.K. Sahewala, learned counsel for the petitioner, who prays for an adjournment due to personal difficulty. The prayer is allowed.
4 weeks.
You are enjoying interim.
My lord.
Then
After vacation, any day.
let this matter be listed after 4 weeks on a date to be fixed by registry. The interim order shall continue till next date.
So very obliging.
So I beg to mention item 37 of hearing list. In this matter, your lordship, Mr. S. Thakur and myself, item 37, my lord. This matter, your lordship, Mr. S. Thakur and myself, we were appearing for the private respondent number 2 the complainants.
You have informed the petitioner?
Yes,
Cons-
We have
I'm
informed.
for
So the last occasion, your lordship, I have informed the court that the brief was withdrawn from us, and your lordship wanted to see the NOC that was granted. If your lordship permit, I can show you the NOC, your lordship.
We'll pass orders when the matter will be called.
Lordship.
Yes, sir. Lordship, I beg to mention item number 31. Lordship, matter may be adjourned for today.
Heard, miss, what is your name?
C. Saike.
C. Saike, learned counsel for the appellant, who prays for an adjournment. Why adjournment?
We need some time to search more decision and take.
On the ground of some personal difficulty. The prayer is allowed. Let this matter be listed
Next week.
17 July.
May please, your lordship. Your lordship, I beg to mention item number 8, lordship. You have taken the concept from the other side. Consent has been taken from the other side.
What is your prayer?
Lordship, heavy personal difficulty, I pray for adjournment.
Heard, Mr. S.A. Bhakhtiar, learned counsel for respondent number 2, who prays for an adjournment. He submits that he has informed learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry. Please.
In item number 20, my lord, additional regulated files, not only records, requisition slip, and
20, call for the,
requisition slip.
Late legal lordship, what I'm praying for listing upon MSC.
Messi, you go to the civil bench 1. This is wrong call.
Wait, please, your lordship. Your lordship, I beg to mention item number 6, your lordship, as my senior is currently out of station. Therefore,
Item number 6.
Item number 6.
What is your name?
Graham Dijong, your lordship.
Right hand name. Learned counsel for the
Dr. B.N. Gogoi.
BN Gogoi is item number 7.
Item 6, your lordship.
BN Gogoi is not there. You verify and then when the matter is called, you in the meanwhile you verify for which item you are mentioning. Wait for your turn. Wait for your turn. Yes.
Very hearing PA, item 15.
Look, petition is behind bars since 15 November 25. On last occasion, CDO was called for by this honorable court.
CD is there.
My lord, here, my lord, scan TCR, my lord, in this matter.
Has
15, my lord.
arrived.
And my lord, scan TCR is shown, my lord. I need some time, my lord, I will go through that, but in the meantime, my lord, TCR, my lord.
What is the matter? NDPS.
22C.
Let him go.
Commercial,
Let him go
commercial.
through.
Only you, for some.
Your lordship. Lordship is item number 7.
Item number 7. Not so and so who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Dr. B.N. Gogoi. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Orders, item 16.
The admission and notice the assigning.
Item 16.
None has appeared for the appellant on call. List this matter in the next week on a date to be fixed by registry.
Item 17. Item 17.
None has appeared for the appellant on call. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item 18.
Item Kune.
Item 18.
Third learned counsel for the appellant. On perusal of the office note dated 13/5/2026, it appears that the trial court records have not yet been received. It also appears that the report which was called for by this court from the Court of Learned Chief Judicial Magistrate indicates that the record is not traceable and he needs some more time is required to trace out the record. The time is granted. Issue reminder for the trial court records. Let this matter be listed 22nd July. Show the name of Mr. P. N. Sharma.
Yes.
Item 19. Item number 19.
None has appeared for the petitioner on call. On perusal of the order dated 10/3/2026 passed by the Lawazima Court, it appears that notice issued to respondent number 2 may be presumed to be served. Let this matter be listed again on 17 July.
Item 20.
My lord, an additional affidavit has been filed.
Wait,
Additional affidavit filed.
we'll wait for some time. Let it come.
My lord, that's requisition is also.
Yes, after some time we'll take it up.
Yes.
Let it come.
Item 21.
None has appeared for the petitioner on call. It appears from office note dated 16/5/2026 that the notice sent to respondent number 2 through speed post has been duly delivered and as such the said notice is held to be duly served on respondent number 2. Let this matter be listed after 2 weeks.
Item 22.
May it please, your lordship. Lordship, matter may be taken after sunset.
Item 23,
Wait, please, Your Lordship. Lordship, on the last occasion, the learned PP was directed to take instructions as regards the service upon respondent number 2, Your Lordship.
Yes, Mr. Shah. What is this case? Appeal is against?
Conviction, Your Lordship, Poxo.
What is this harm, my lord? Liquor spring. Yeah.
What is the sentence imposed?
10 years, Your Lordship.
Miss, what is the name? S. Kotoki, learned counsel for the petition, appellant. Also Mr. B. Sharma, learned additional public prosecutor, who has submitted that the notice issued to respondent number 2 through jurisdictional police station has been duly served. However, none has appeared for the respondent number 2 on call. Since this appeal involves conviction of the appellant under
376.
no, since this appeal also involves a case under POCSO Act, this court is inclined to appoint one amicus curiae to defend the cause. Any amicus present in the court? Yeah. You defend. Accordingly, Ms. T. Parashar, learned counsel whose name appears in the list of amicus prepared by registry of this court, is hereby appointed as amicus to defend the cause of respondent number 2 in this appeal. The appellant is directed to furnish copies of memo of appeal along with annexures to the newly appointed amicus curiae.
Lordship, we filed an IA for suspension of the sentence.
The appellant/applicant is also directed to furnish copy of interlocutory application to newly appointed amicus curiae within 3 days from the date of this order. Let this matter be listed again on 23rd June.
Will file our.
The 23rd June or
Chip,
after vacation?
17th, 16th of July.
On 16th of July. The state may file its written objection in the meanwhile. List accordingly.
Highly.
item 24,
The registry is directed to reflect the name of Ms. T. Parashar in the cause list as the amicus curiae for respondent number 2 henceforth.
I mean, if your lordship indulgence, mentioning about 21, it is past for one. I was stuck off in the.
We'll take it up after some time.
Yes, Lord.
After some.
Obliged.
Yes.
May I please, the Lord? So, my Lord, interlocutory application. my Lord,
This is item number
24, my Lord. My Lord, for the condonation of delay, my Lord, there is a 551 days of delay in, my Lord, challenging the order. My Lord, order pertaining to Jimma of a vehicle, my Lord, which have been rejected. But
500.
551 days, my Lord. My Lord, what has happened, my Lord? The petitioner is a victim of recent eviction exercise which had been carried out in Sunapur area, my Lord. That is one ground we have taken, as well as some health grounds are also there. But my Lord,
What vehicle? Jimma what?
Jimma of a vehicle, my lord.
Where is the vehicle?
Vehicle is now still in the concerned police station, my lord. In Lakhimpur, my lord.
Who are you?
I am the registered owner, my lord.
Okay. Yes, Mr. Sharma.
Well, already our objection on IM, my lord, it is filed. My lord, we have taken the.
I against the condonation.
Yes, my lord, we have taken the stand, my lord, that the medical document, my lord, no supporting medical document is annexed to the, my lord, IA petition. That is in the court.
Yes, Mr. Bhuya, what is
My
the
lord,
ground?
Not the ground which we have adopted.
Which para?
Paragraph number 7, my lord, at page 10. More than, my lord, that the applicant begs to humbly submit before this honorable court that it has been more than 2 years since so and so that the seized vehicle of the applicant has been in the custody of the police, and after that, although it was allowed to be released to the applicant by judgment dated, the learned additional session judge so and so Lakhimpur.
Which para you are reading?
Lord, I am reading at page 10, paragraph 7 of the IA, my lord.
Yes.
My lord. May I read, my lord?
Yes.
That the applicant begs to humbly submit before this honorable court that it has been more than 2 years since 12/7/2022 that the seized vehicle of the applicant has been in the custody of the police. And after that, although it was allowed to be released to the applicant by judgment dated by the learned additional session judge so and so by criminal appeal number, but was directed to be released to the Jimma of the only on furnishing a bank guarantee to the tune of rupees so and so before the court of the learned Eleka magistrate. However, this direction has been passed by the learned additional session judge erroneously and in abject misinterpretation of the law, particularly that of the Assam Cattle Preservation Act 2021. The grounds wherein the aforesaid act has been misinterpreted has been discussed in detail in the connected criminal revision petition. Now, if the delay of 551 days is not known, my lord, the
Ground for delay I am searching.
Yes, my lord. My lord, from paragraph,
Why so much delay?
yes, my lord, paragraph 4. For around 3 months continuously, my lord, paragraph 4 at page 7, my lord. That the applicant humbly begs to submit that although the learned additional session judge Lakhimpur, North Lakhimpur by an order in criminal appeal number so and so, however, the applicant received the certified copy of the judgment only on so and so. After that, the applicant was contemplating upon ways to challenge the aforesaid judgment by approaching the High Court. However, during that period of time, suddenly the health condition of the applicant deteriorated and he had to admitted in hospital. Subsequently, the applicant was diagnosed with some serious illness, and the result, he had to be under treatment, undergoing different medical procedure for almost around 1 year. For around 3 months continuously, the applicant was admitted in so and so, and after that, for the later part of the 1 year period, the applicant had to visit hospital almost every month for undergoing blood test and other diagnosis, and he had to be undergone the regular medication, checkup, etc.
You have annexed?
No, my lord, that mistake we have, my lord, admittedly, we have not annexed any such medical reports, my lord. So, my learned friend's objection, my lord, without any record, my lord, I cannot say, my lord, that it is a not a tenable objection. But, my lord, admittedly, I have come across the petitioner, my lord, his condition is not so good. And that apart, my lord, he has been recently subjected to, my lord, eviction in Sonapur, Kochutoli area, my lord. Therefore, my lord, his entire house has also been demolished, and as a result, some papers and documents is also missing, my lord. The condition is not so good, my lord. So, my lord, it is a matter of rights of the vehicle, my lord. My humbly pray, my lord, that the matter may be heard on merit, my lord. Other options are not available because, my lord, the bank guarantee of
Mr. A.R. Bhuyan. Yes, Mr. Sharma, anything? Heard Mr. A.R. Bhuyan, learned senior counsel assisted by Miss
S. Laskar.
S. Laskar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed by the petitioner Muhammad Rafiqul Islam under Section 5 of the Limitation Act 1963, praying for condoning the delay of 551 days in filing the connected criminal revision petition against the judgment and order dated 12/5/2023 passed by the Court of Learned Additional Session Judge within bracket FTC Lakhimpur, North Lakhimpur, in criminal appeal number 12 within bracket 2/2023. Learned counsel for the petitioner learned senior counsel for the petitioner submits that the vehicle of the vehicle bearing registration number AS01FC8243 belonging to the petitioner was seized in connection with GR case number 749/2022 corresponding to Bhilpuria PS case number 129/22. The stop. Thereafter, the petitioner approached the Court of Learned Subdivisional Judicial Magistrate Lakhimpur seeking Jimma of the said vehicle. However, by its order dated 2/3/2023, the said court rejected the prayer for Jimma. Stop. Against this said order, the present petitioner preferred an appeal before the Court of Learned Additional Session Judge, FTC. Same was registered as criminal appeal number 12 within bracket 2/2023. Learned senior counsel for the petitioner submits that the appeal filed by the present petitioner was allowed. However, the Jimma of the said seized vehicle was, though granted, however, though the Jimma of the seized vehicle was granted to the present petitioner, a condition of furnishing bank guarantee of to the tune of rupees 10 lakh was imposed, which, according to learned senior counsel, is a cumbersome condition and has been imposed due to wrong interpretation of the applicable law. The said order is impugned in the connected criminal revision petition. Stop. The reasons for delay in preferring the connected revision petition has been stated by the petitioner in paragraph number 4 of the instant interlocutory petition. Namely, the petitioner was suffering from ailment. What ailment?
My instruction is that some liver issues below, not been.
Ailments and had to be under constant medical treatment. Stop. Learned senior counsel for the petitioner has further submitted that recently the petitioner has been evicted from his homestead land, and in the process he has misplaced several documents and therefore could not annex the medical document along with the instant interlocutory application. Stop. On the other hand, learned additional public prosecutor has opposed the prayer for condonation of delay, saying that the delay involved in this case is a huge delay of 551 days. He further submits that though the petitioner has taken ground of ailment, however, no medical document has been furnished to substantiate the said ground. I have considered the submission made by learned counsel for both sides. and have gone through the materials on record. The petitioner intends to impugn the order by which Jimma of the vehicle of which he is the registered owner was granted to him. However, with a onerous condition of giving bank guarantee to the tune of 10 lakhs. Though the petitioner has not annexed any medical document to support the contention of his ailment. However, the averments made in this interlocutory applications are supported by an affidavit. And since this is an application for condonation of delay, a liberal approach is taken by this court so that the criminal petition filed by the petitioner can be disposed of on merits. Accordingly, the delay of 550 days in preferring the connected revision petition is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected revision petition and list the same for admission. No, it's a Bureau Bandharagam. On 24th June.
Highly obliged, my lord. Delay of 551 days.
Yes, 551 days.
Obliged.
Extreme sign put number 1 then.
Item number?
19 then.
We-
19.
Yes,
I was also missed the call here.
My lord, only thing is that you also fix the date. If there is an interim order, that may be confusing.
My concern is that I have gone through the record. It is long pending case and we
We'll take it up. We'll take it up.
yet filed our reply, so we may be permitted to file reply. That is my concern. Affidavit in reply.
I have no, actually.
Item no file asani. But you have to wait for your turn. You cannot bulldoze.
This matter has been passed, my lord. That is why I mentioned.
So 19 is over. Order has been passed. That is why.
That is why I mentioned.
19 April we say. Okay, heard Mr. N.N.B. Chaudhary, learned senior counsel assisted by Mr. K. Kashyap, learned counsel for the petitioner. Also heard Ms. M. Kumari, learned standing counsel, CBI, who prays for some time for filing written objection. The prayer is allowed. Let this matter be listed. 17 July. The interim, any interim order is there. The interim order shall continue till next date.
Acha, please.
I'm extremely sorry, my lord. I'm in court number 1.
Me also missed.
Item 25.
May I please?
আৰু মাজত আৰু এটা থাকি গৈছিল নহয় মাতি দিব পাৰে next. Yes.
The appellant convicted under section 4 subsection 1 of POCSO for imprisonment of 10 years and to fine of rupees 10,000 and further convict sentence to appellant impose of 500 rupees under section 413. The LCR is received lawsuit. There is a IA for suspension of sentence. I know other party also file objection.
Respondent number 2 is represented.
Yes, Lordship. There's a amicus.
You are ready, Mr. Goswami?
Lordship, this for my lord, only for the IL.
Yes. Make your submission.
Lordship.
ISO.
So here in this case, Lordship, the appellant convict and sentenced to suffer rigorous imprisonment for 10 years and to fine of rupees 10,000 under section 4 subsection 1 of POCSO and further convict sentenced to appellant to impose a fine of rupees 500 for offense under section 341 of IPC. In this case, learned
Default stipulation. Stop. the aforesaid judgment and order has been impugned by the present applicant in the connected criminal appeal number 424/2025. Stop. The facts relevant for consideration of the instant interlocutory application in brief are that on 1/11/2021, the mother of the victim girl had lodged an FIR before the officer in charge of Gogamo police station, inter alia, alleging that on 30/10/2021, at a 17 years, 10 months, and 10 days at the time of alleged incident, and therefore he was produced before the Principal Magistrate Juvenile Justice Board, Themaji. Stop. After completion of the investigation, offense report / charge sheet was laid against the present appellant before the Juvenile Justice Board, Themaji. However, during preliminary assessment conducted under Section 15 of the Juvenile Justice within bracket Care and Protection of Children Act 2015, it was held that the present appellant is required to be tried as an adult, and accordingly the aforesaid case was transferred to the court of Special POCSO, Court of London, to the transfer to the Children's Court, that is the Court of Session Judge Themaji, for trial. After the trial, the present appellant was convicted under Section 4 of the POCSO Act 2012 and Section 341 of the Indian Penal Code, and accordingly was sentenced in the manner as has been described in the foregoing paragraphs of this order. Mr. What is your name? Mr. B. Islam, learned counsel for the applicant, has submitted that the present applicant has impugned the aforesaid judgment in the connected appeal, and there is every possibility of getting a favorable result in the pending appeal. He submits that the trial court had erred in convicting the applicant under Section 4 of the POCSO Act 2012 for committing penetrative sexual assault. He submits that the testimony of he submits that though the PW5, that is the victim girl, has deposed that she was raped by the present applicant when she was coming back to her home, in a paddy field, at about 7 p.m. However, the medical examination report of the victim girl does not show any injury marks on the person of the victim girl. He submits that even the hymen of the victim girl was found intact, and victim girl, while deposing as PW5, has stated that the alleged incident occurred in a paddy field. However, the sketch map which was exhibited it was exhibited as exhibit, sketch map prepared by the investigating officer shows no paddy field. Where is the sketch map?
Page 29,
Page?
Page 29, Exhibit P4, PW7.
Page 29.
Sketch map, here in the mention,
Where is the sketch map?
sketch map, I have no next.
Where I'll get the sketch map?
The record.
Record is. Do you have a copy of sketch map?
No.
During the pendency of the connected criminal appeal, ये line complete करो. Criminal appeal and allow him to go on bail during this period. On the other hand, learned addition, Mr. MP Goswami, learned additional public prosecutor, has opposed the grant of bail, opposed the suspension of sentence during the pendency of the present appeal, pendency of the connected appeal, on the ground that the contradictions regarding narrating the incident by the victim girl to the parents in her testimony before the court and to her mother only in her statement recorded under 164 CRPC was not brought to the notice of the victim girl while she was cross-examined by the defense side. He also submits that otherwise also this contradiction does not go to the root of the case. He also submits that the definition of penetrative sexual assault examined to that effect, and hence the said contradiction is also not fatal to the prosecution case. He also submits that since the connected appeal is ready for hearing, the matter may be finally heard and disposed of instead of letting the applicant go on bail at this stage, as the offense involved in this case is a serious offense. Stop. On the other hand, Ms. T. Parasha, learned amicus curiae, has also during learned counsel for the petitioner add one line. Learned counsel for the petitioner has cited a ruling of this court in support of his submission, has cited a ruling of this court in the case of Pramod Yadav versus State of Assam, within bracket, judgment dated 1/4/2025 in criminal appeal number 303/2023. Now, the legal aid counsel. The legal aid counsel has submitted that in an offense, in a case involving sexual offense, the testimony of victim is sufficient to come to a finding of guilt of the accused in such cases if the said victim is found to be a sterling witness. She submits that in the instant case, the stand of the victim girl throughout the case has remained consistent, and the prosecution side would not demolish her testimony during cross-examination. She also submits that the contradictions pointed out by the learned counsel for the petitioner do not go into the root of the case. She also submits that the corroboration by medical evidence is also not necessary in offenses involving in cases involving sexual offense under section 376 or under section 4 of the POCSO Act. She submits that if the court comes to a finding that the testimony of prosecutrix is trustworthy and she is a credible witness, her sole testimony may be relied upon to come to finding of the guilt of the such an accused. She also submits that there is unlikelihood of the wherever I have used appellant, petitioner. There is unlikelihood of petitioner getting a favorable order in the connected appeal, and hence she also submits that since the offense involved in this case is a heinous offense under POCSO Act, the prayer for suspension of sentence during the pendency of the connected appeal may be rejected and the appeal may be heard finally. Stop. In support of her submission, she has cited following rulings. Phul Singh versus State of Madhya Pradesh, reported in 2022, 2 HCC 74. Number 2, Ranjit Hazarika versus State of Assam, 1998, 8 SCC 65. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the submissions made by, I have also gone through the rulings cited by learned counsel for the both sides in support of their respective submissions. It appears is ready for hearing. Stop. The while considering an application for suspension of sentence under section 430 of BNSS, this court is reluctant to give any opinion or give any definitive opinion on the respective contentions made by the learned counsel for respective parties at this stage, as it may have a bearing on the final outcome of the appeal. However, had this been a case where any of the contentions raised by learned counsel for the applicant gives an indication that the connected appeal is surely going to end in acquittal, this would have been a case where sentence may have to be suspended during the pendency of the connected appeal. However, this court is of considered opinion that that is not the case in the instant case. The contentions raised by the learned counsel for the appellant needs to be examined, and same can be done only in final hearing. Whether the contradictions pointed out by the learned counsel for the appellant affects the core of the prosecution case or not also needs to be examined during the final hearing of the connected appeal. This court may, however, is of the opinion that in every case where conviction under section 4 of the POCSO Act is made, there may not be a necessity of examining as to whether the victim girl has sustained injuries in her private parts, or that whether her hymen has been ruptured or not, as the imposed on the petitioner at this stage. However, considering the fact that the petitioner was a juvenile at the time when the alleged offense was committed, the connected appeal is required to be heard expeditiously. Accordingly, let the connected appeal be listed for hearing on 28th of July. This interlocutory application is accordingly disposed of.
Contains 29.
29 July. July. I'm taking a short break.
15.
Yes.
Charge against the petitioner has been framed before the learned trial court in connection with this case. And so far as my lord, considering the period of detention,
How much?
mm, since 15 November 25, my lord.
How much time?
205 days today. my lord.
How many months?
My lord, 15 November, around 6 months, 2 or 3 days. Yes, sir, 6.5 days.
What was the contraband?
Contraband was some codeine syrup was recovered
How much?
from a vehicle, 240 bottles. But on that,
6 months is not a prolonged incarceration.
no, my lord, because I have surrendered and surrendered because I know that the case. I am not guilty. That's why I have surrendered. But while my arrest has been.
No, how you will overcome 37, embargo of 37?
Yes, sir, I will explain, my lord. First of all, my lord, the contraband was seized by the police prior to 6 months of my surrender. On the date of registration of the affair, 6 March, by alleging that this codeine syrup was found from a vehicle which was in the premises of the present petitioner. But at that particular time, he was not available to his house. So there was no conscious possession. And with regard to section 37(1 is complied with because your lordship, my lord PP is before the honorable court. With regard to section 37(2, my lord, let me explain, my lord, because there was no conscious possession of the contraband. And so far as the case, prosecution case, only FIR cannot be treated to be a substantive piece of evidence. There are so many factors because this man was not available. If this man would be available at that particular time, he definitely would have been arrested by police. So there may be some other factors with regard to the recovery of the contrabands from the premise. So the prosecution case is doubtful. So let this case before the learned trial could be proved, and the important thing is that he is a local resident of the jurisdiction of the learned trial court. So there is no possibility of escape from the trial, and he will regularly appear if he is granted bail by this honorable court by imposing any condition. He will
No.
never escape.
You have to overcome 37 first.
Yes, because there was no conscious possession. And so far as this contraband of codeine syrup, that may be carried out by any transporter or at the instruction of any pharmacy license holder through the vehicle. So that
Whether charge has been framed.
on the same section. Same section. That may be belongs to some other any other drug dealer. So and this codeine syrup is permissible.
Now when charge is framed, prima facie something has been found against you, therefore.
For practical purpose, I may submit before your honor with you my some respectful submission that charges are framed very casually by the learned trial court.
You challenge that.
Without considering each and not just prosecution projects the case under so and so section. Only accused stand in the dock. Whether have you committed this offense, I would deny and claim to be tied. These are the practice is going on before, except some cases.
No, if charge ought not to have been framed, then you could have challenged it. Yes. Any other ground apart from not.
No, my lord, main particular thing is that, my lord, I have surrendered. And grounds of arrest is one of the vital aspects in this case. Because when police confirmed my arrest on 15th of November, after 3 days of police remand, then police has bound and duty to provide the grounds of arrest. But that has not been done in this case, my lord.
You were not arrested.
No, my arrest has been confirmed after interrogation for remaining 3 days police remand.
You yourself surrendered.
Yes.
And the court remanded you to judicial.
No, I have been remanded for 3 days.
Police remand.
Police remand. Thereafter, police confirmed my arrest. Yes, he should be remanded to judicial custody after 3 days of interrogation. Then, while making a forwarding report for judicial custody, police has the bounden duty to provide the grounds of arrest. But if your lordship would peruse the page 25, annex 4. Your lordship would not find any grounds of arrest even before the learned magistrate also. Just police have made a bail objection.
Because you were not arrested, you yourself surrendered and only objections could have been made.
Yeah, in regard, because ultimately, if I would not be arrested, then how I have been sent to jail? Because
By a judicial order.
no. How I can be gone to judicial custody without arrest? Because therefore, my humble submission before lordship is that police has not adhered the provisions, mandatory provisions of section 36, 47, and 48 of BNS. These are the mandatory aspects of vital ground.
Okay.
That is not reflected in the entire case, my lord, so far as the record is before a lordship. And I have explained this.
Where is your remand order?
Remand order on the same date, my lord, 15/11,
Which at page 26.
page 26.
And police remand order.
Police remand order was on 11/11/25.
Page number?
Page number 23, my lord. And accept me.
Yes.
Here, my lord, that is the affair dated 6/3/2025. And my lord, the search sheet is, my lord, 22/11/2025, my lord. And my lord, already my senior colleague has submitted, my lord, that is in page 23, my lord, of the petition, my lord. This is the order dated 11/11/2025, my lord. Page 23 of the petition, my lord.
Yes.
May I read, my lord, the related
Yes.
part of the order, my lord? 11/11/25, my lord. Before the, my lord, Special Judge NDPS Romnia, my lord, it is case record is put up today. Accused so and so surrendered before this court, height petition number so, and prayed for bail, showing that he has been wrongly named in the affair and has voluntarily appeared before the court. Now, my lord, it means that, my lord, he has filed a bail applications, my lord. He was not arrested till that point of time by the, my lord, that is the investigating agency. He is aware about the every fact because he has filed an, my lord, that is the bail petition. So regarding, my lord, in this case, my lord, regarding the part of the arrest, the 47, 48, and also, my lord, that the 36 will not come. It is before the, my lord, the honorable, my lord, trial court, my lord, that time, learned special judge, my lord. So after perusal of the case record, it appears that the alleged offense is under 22C of the NDPS Act. There is an embargo under the 37 of the NDPS Act. Considering those aspects, the bail prayer is rejected and the accused is hereby remanded to judicial custody till next date. In the meantime, intimate the IO of this case fixing 12/11/2025 for production. Now, my lord, the next page 24, my lord. Later on, IO so and so of Bayhata PS is appeared along with a prayer seeking 5 days police custody of the accused so and also mentioned the grounds of the remand that during preliminary investigation it has been revealed that the accused is a part of the large nexus engaged in illegal activities. Therefore, further interrogation is essential to uncover. I am not coming, my lord, entire thing, and my lord, as per that, my lord. However, after perusing the FIR as well as the ground of the reasons of the prayer remanded to the accused, I am of the view that for proper investigation and find out the actual facts and circumstances of the crime, the prayer for the IO is allowed, and accordingly, accused so and so is given 4 days police custody. The IO is directed to follow Honorable Supreme Court's guideline in DK versus judgment.
What is the corresponding provision in BNSS to 167 CRPC?
That is the My lord, this is my lord, 167 is my lord, 187 now in BNSS, my
One
lord.
eighty-seven.
187 of BNSS, my lord. No, my lord, it's wrong, my lord.
Yes.
As per that, my lord, this is my lord compliant, my understanding. So, my lord, because of that, my lord, this arrest part is, my lord, that is on the basis of, my lord, his surrender, my lord. There's a bail prayer is made, my lord, that is, my lord, rejected, then, my lord, judicial custody. And after the prayer made by the, my lord, investigating agency, my lord, then, my lord, to the, my lord, police remand, then thereafter JC, my lord. So that is the first one. Now, my lord, regarding the possession of the contraband, my lord, admittedly, my lord, not in the conscious possession, but from the residence and from the vehicle, my lord, that is in the residence, my lord, that is of the, my lord, owner, my lord. So though it is not, my lord, the conscious possession, but, my lord, it is a constructive possession, my lord. My lord, right now I don't have that authority, my lord, Madan Lal versus State of Himachal Pradesh, my lord. And in various other cases also, my lord, the both the things constructive and, my lord, the conscious possession is discussed, my lord. So here is a case, my lord, admittedly not conscious possession at that point of time, his physical presence is not there, but from his residence, from his, my lord, house and from his vehicle, my lord. So it is a, my lord, constructive possession. My lord. Now, my lord, in this case, my lord, charges has already been framed, my lord, as my learned senior colleague submitted, my lord. And that is, my lord, it is charges frame on, my lord, 5/2/2026, my lord. 5/2/2026, my lord. And then thereafter, my lord, it is fixed for evidence. Now it is in the evidence stage, my lord. First date was, my lord, after, my lord, February this 13/3/2026. Then, my lord, 10/4/2026, 23/4/2026, 4/5/2026, my lord. And next date is fixed on, my lord, 29/5/2026. Record available up to, my lord, 18/5/2026. In, my lord, 1, 2, 3, 4, these 4 dates, my lord, no PWs were examined, my lord. As per the order set, my lord. But, my lord, till today, my lord, commercial quantity and, my lord, days are, my lord, that is the 205 days, my lord. That is, my lord, below, my lord, 7 months.
Okay.
So at this stage, my lord, it's because, my lord, prolonged incarcerations, my lord, if it is, my lord, it is not, my lord, will not come, my lord, at this stage. But, my lord, like, kindly give a direction to the learned trial court, my lord, to expedite, my lord, the things, my lord.
Heard Mr. A. Paul, the learned counsel for the petitioner. Also heard Mr. K. Basho, the learned additional public prosecutor appearing for the state. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Nazir Kazi alias Boga, alias Syed Nazir Kazi, who has been detained behind the bars, praying for bail in connection with NDPS case number 30/2025 pending before the Court of Learned Special Judge Kamrup Rangya under Section 22C of the NDPS Act 1985. The gist of accusation in this case is that on 6/3/2025, one Daisy Nath, SI of Police, had lodged an FIR before the officer in charge of Bayata Sareli Police Station, Inter Alia, alleging that an information has been received from reliable sources that the present petitioner has kept huge quantity of cough syrups in his residence and also selling the same in by using his Alto car and scooty. Accordingly, a search operation was made by the Bayhata Sareli police, by the police of Bayhata Sareli police station, and 240 numbers of 100 milliliter bottles of Broncon C cough syrup containing codeine phosphate were recovered therefrom. On receipt of the aforesaid FIR, Bayhata Sareli PS case number 61/25 was registered under Section 22 within bracket C of the NDPS Act 1985 and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid against the present petitioner and the trial has commenced. After framing of charges against the present petitioner, to which he has pleaded not guilty. Stop. It is pertinent to learned counsel, Mr. A. Paul, the learned counsel for the petitioner, has submitted that the petitioner is innocent and nothing was found from his conscious possession, as he was not in the place from where the recovery was made. Stop. He submits that he has himself surrendered before the trial court on 11/11/2025 and surrendered before the trial court on 11/11/2025, which indicates his innocence in the instant case. He further submits that the trial court on the next date, that is, trial court on the same day of his surrender before it, had remanded the petitioner to police custody for 3 days. And after production of the petitioner before the police custody, before the trial court, from the police custody, he was remanded to judicial custody. However, no grounds of his detention were communicated to him. He therefore submits that in this case, the provision of Section 48 47, the provision of section 36, 47 and 48 of BNSS has been violated. He submits that he is entitled to get bail on that grounds. He also submits that since nothing was found from the conscious possession of the petitioner, the embargo contained in section 37 is also not applicable to in his case. He also submits that the petitioner has been detained behind the bars for more than last 6 months and trial is not progressing. Hence, he submits that on the ground of prolonged incarceration also, the petitioner is entitled to get bail. Stop. On the other hand, Mr. K. Bushra, the learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioner on the ground that the contraband seized in this case is of commercial quantity and therefore embargo of section 37 of the NDPS Act is applicable to this case. He submits that the petitioner has failed to overcome the said embargo. He also submits that since in this case the petitioner himself surrendered before the trial court and he was not arrested by police at the first instance, hence the question of preparing arrest memo under section 36 and complying with the mandate of section 47 and 48 does not arise. He also submits that since this is a case involving commercial quantity of contraband, a period of 6 months may not be regarded as long enough incarceration to give him benefit of bail on the ground of prolonged incarceration. So I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. So upon perusal of the records, it appears that though the petitioner was not present at the time when the seized contraband were recovered. However, it is clear from records that said contrabands were recovered from the house of the present petitioner. It is your house.
It is to be proved by the prosecution before the learned trial court, whether it was rented house or somebody else. It is the case of the prosecution that is my house. But at this stage, I cannot admit this thing.
But are you denying?
Yes, my lord. And prosecution case, this is the prosecution case.
House of the petitioner. Merely because of the fact that the petitioner was not present at the time when when the recovery of contraband was made from his house. It may not be said that the petitioner may be regarded as innocent at this stage. The third aspect is required to be considered during trial. So, however, prima facie, it appears that the seized contraband were recovered from the constructive possession of the present petitioner. Stop. As regards non-compliance of section 36, 47 and 48 are concerned, said provisions are applicable only when a person is arrested by police officer or other such officer under the provisions of BNSS. However, in the instant case, the petitioner was not arrested at the initial stage. Rather, he himself surrendered before the trial court and he was remanded to police custody as well as judicial custody by a judicial order which was never put to a challenge by the petitioner. This court is therefore of the considered opinion that the provisions contained under section 36/47/48 of the BNSS are not applicable to the facts and circumstances of the present case. As regards the bail on the ground of prolonged incarceration is concerned, this court is in, there is no this court is in agreement with the legal proposition that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act 1985. Stop. However, as to how much incarceration may be regarded as long enough to be considered as prolonged incarceration to give the benefit of bail to
My lord, the Honorable Supreme Court in different cases in different views, but my lord, the minimum is my lord, lordships also different.
No,
orders.
this matter has been referred to. This matter has been referred to a larger bench of Supreme Court because there are different views taken.
Sometimes
it has been referred to a larger bench that this question itself and the reference is still pending. So it is for the individual court to decide. That is my view. What was the last thing? No. Sentence पूरा पढ़िए. Depends on fact and circumstances of individual case. Stop. In the instant case, since the contraband seized in this case is of huge quantity of 240 numbers of of bottles containing codeine phosphate, the incarceration of less than 7 months cannot, in the considered opinion of this court, be regarded as long enough to give the benefit of bail to the petitioner on that ground. Stop. In view of the discussions made and reasons stated in the foregoing paragraphs, the prayer for bail is rejected. Stop. However, the trial court is hereby directed to make all endeavors to dispose of the NDPS case number 30/2025 as expeditiously as possible.
Item 20.
My lord. No, additional activity, this was filed, my lord.
I say.
There is some kind of mistake in page 2.
If, okay. Yes.
There's a mistake in cost title and page 2, the section of charge sheet not inserted, my lord. That is why a liberty is granted. According to the page 2, my lord, charge sheet number 239, it should be section 420 and 376. And page 2, my lord, an impugn charge sheet number 239/21. No section is inserted. That is why, my lord, when the FIR is there, section is under 366. Now it will become 376. That is why, my lord, it should be corrected. So liberty is granted. To that effect, I have filed an affidavit, additional affidavit, para 4. I have given this post title, my lord. So the correct, my lord, post.
Okay. Okay.
So, my lord, your lordship may allow an amended post title. I may be. That is why additional. I brought this accurate.
No, I am not getting you.
My lord, because
This criminal petition, what have you challenged?
I have challenged the charge sheet as well as the.
Okay, then why this additional affidavit was filed?
My lord, in page 2,
Page 2 of.
of this main criminal petition, my lord,
Ah.
I have not mentioned the sections.
Okay.
So that is why through additional affidavit, liberty, I have brought in the additional affidavit, para 6 of my additional affidavit. It should be like that. This section should be.
Then you should have filed an interlocutory application if there is.
Mane,
If you want to amend your petition, this should not be by way of additional affidavit. You should have filed an IA seeking leave to, but we are otherwise, where is the mistake? Show me the mistake.
page 2 of the criminal petition. In the impugn charge sheet dated so and so 239, here section is not mentioned.
Which para?
My lord, cost title, page number 2, cost title of the criminal petition, my lord. Second, in the matter of, my lord, impugn charge sheet. Page 2 of the criminal petition.
Yes, page 2 of the impugn charge sheet dated 3.
These are correct, but sections are not mentioned.
Sections are mentioned 120B
But that is the
PS case.
PS case section. It now reduced to 420 and 376 only.
Okay.
So that is.
You file an additional, you file and corrected.
Last occasion, madam, that everybody get it in that manner. That is why I have. Okay, madam. I am directed to.
But
Yes, madam. That's.
you were allowed to file a. Oh, you were directed by the court to file an additional.
If so proceeded, then I can take also, madam. That is why.
Where is the additional affidavit?
Madam, today only I have brought this.
What is it?
By the petition, it is good. Para 6, I have mentioned it.
Okay, heard Mr. M.J. Barua, learned counsel for the petitioner. Also Mr. K. Bushra, learned additional public prosecutor, as well as Mr. Ainuddin, appearing for respondent number
2.
Respondent number 2. Learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit as was directed by this court by its order dated 8/5/2026. However, he submits that the cause title of the criminal petition filed by the petitioner, wherein at page 2 he has only mentioned the charge sheet number without indicating the sections without indicating the penal sections under which the charge sheet has been filed needs to be corrected. And he prays for filing an amended cause title. The prayer is allowed. The petitioner shall file an amended cause title rectifying the typographical error pointed out by him on the next date fix. Let this matter will be decided on 22nd June.
Item 21.
Lordship, in this case, service upon the respondent what you already complete, Lordship. Yes.
Service upon respondent number 2. What is the method?
Regarding quashing of the FIR, I lodged on 28/4/2024, Lordship.
What affair?
That is FIR regarding section Panbazar Police Station case number 93/24, registered under section 153A 171G 505 1B of the Indian Penal Code, as well read with section 60C(f) of the Information Technology Act. The all ingredients are not constituted in this case, Lordship. It is only on the basis of a tweet that was already in the X platform, and the petitioner showing that he expressed his some opinion. On the basis of that, that case was registered by one third person. Not he's not at all
Third person is the respondent number 2.
respondent number 2, Lordship. He is not one way affected in this case, Lordship.
What was tweeted? Where is that tweet?
Expression is given by the Lordship. It is
Where is the FIR?
FIR is page 32, Lordship, NH 1.
CD is there. CD will be required.
Yes, sir.
Investigation is going on. Stayed.
No coercive steps has been taken.
So ultimately stayed.
Ultimately,
CD would be required.
Yes.
We'll call for the case diary. Heard Miss M. Dev, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. On perusal of office note dated office note dated 16/5/2026, it appears that the notice issued to respondent number 2 in this case has been duly served. has been duly served. Stop. However, considering the nature of relief sought for in this criminal petition, the case diary of Panbajar Police Station case number 93/2024 would be required for consideration of the instant criminal petition. Hence, learned additional public prosecutor is requested to produce the case diary on the next date fixed. Let this matter be listed. July.
21 July. I'll be out of station. So by June,
By service.
after 25,
20.
20.
27 July. 27 July. The interim order shall continue till next day.
Item 22.
Yes.
Please, Your Lordship.
Main appeal to the
This appeal has been filed against acquittal, my lord. By
appeal
the
against acquittal.
acquittal by the victim in person, but inadvertently, my lord, the wrong section has been put, my lord. So, I may be
Why this interlocutory application?
because of, I have filed, 4-1 under section 419. In 419, leave is required, my lord. Therefore, this is for leave petition. So, my lord, it, what to have been filed 413, my lord.
Which order you are impugning?
Because, my lord, the, acquittal order, my lord,
Acquittal by which court?
by the Ramat Session Judge.
Sessions Court has acquitted. Okay.
So,
Where is the impugn order?
my lord, page number 14 in the appeal. Start from 14. Request to amend the first statement.
Yes. This is by Sessions Court.
Yes, ma'am. This is.
Then you withdraw this interlocutory application and file another interlocutory application praying for.
If I withdraw this IA, my lord, then my FTR.
Or you, this I is for leave. Leave may not be required once we allow you amend your cause title to 413. This I is under 419. That may not be required. So you file another I. Heard Mr. H.A. Ahmed, learned counsel for the applicant. Also heard Mr. K. Basho, learned additional public prosecutor. Learned counsel for the applicant submits that the connected appeal has been preferred by the present applicant, who is also the victim of the case wrongly under section 413 of BNSS 2023, whereas it ought to have been under section 4, wrongly under section 419 of BNSS, whereas it ought to have been under section 413 of BNSS. Hence, he prays for some time to file an appropriate interlocutory application seeking amendment of the cause title of the connected appeal. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed in registry.
Item 26.
Yes.
Service report is awaited, your lordship, upon respondent number 2.
What is the matter? This criminal petition has been, what are you challenging?
Fair of the facts, your lordship.
Why?
My senior is on legs, your lordship.
You are also on legs.
Oh, your lordship.
Heard Miss S. Paul. La-
A. Das.
On behalf of Mr. A. Das, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. On perusal of, when have you taken steps? Oh, on perusal of the office note dated 30/5/2026, it appears that the service report in respect of notice issued to respondent number 2 is awaited. Has not yet been received. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post before this court on the next date fixed. List this matter again on 22nd June.
27.
May I please, your lordship? My lord, the office note dated 1st of June says that service on respondent number 2 is complete.
Complete.
Yes, my lord. The tracking report has come and it says that the item has been delivered successfully.
What is the matter?
My lord, it is a quashing petition. Offense is under section 419 and 493 of IPC. I'm challenging the FIR, the charge sheet, and finally the PRC case that has been registered.
Yes, you have to defend.
Then madam, we'll fix for admission. Madam.
We will fix it for
My
admission.
lord, my lord.
Heard Mr. A. Khan, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Office note dated 1/6/2026 shows that from the postal track consignment report, it is indicated that the notices issued to respondent number 2 has been delivered. How many respondents are there?
Respondent number 1 is the state, my lord, and respondent number 2 is the complaint.
Has been delivered. Hence, the notice is held to be duly served on the said respondent. Trial court records would be necessary.
My lord, it may be called.
Yes. The record for consideration of the instant criminal petition, the records of the trial court may have to be produced. As such, let the scanned copy of the PRC case number 1719/2025 along with the scanned copy of the connected case diary be called for the trial court. Registry to take steps for requisitioning the trial court records. Requisitioning the scanned copies. Let this matter be listed 22nd July.
My lord, interim may kindly be confirmed.
The interim order shall continue till next day.
Please, my lord.
Please.
Item 28, Millard, next item, Millard. I want to leave the court, Millard. So, for the service report, Millard, matter was fixed today. We have taken 2 times the step, Millard.
That is awaited.
So we can maybe allow, Millard. Otherwise,
Okay, at 2 we'll pass orders, but you may leave. We'll show your
my
presence.
junior will be present.
Okay.
Anybody else, judgment, item 49?
For reasons mentioned in the judgment, this appeal is dismissed.
Highly obliged.
May it please your lordship, statutory deposit may be required.
Obliged.
Item 58.
If the service report was abated, last two occasion we take steps, lordship, 8/12 and.
You have any report?
No, lordship, still waited.
So MS can be approved. This two occasions were supposed to take it, lordship. Long pending case.
Heard Mr. S. K. Chetri, learned counsel for the appellant. Also heard Ms. S. H. Bora, learned additional public prosecutor. It appears that who submits that she has no information regarding service of notice upon the respondent number 2 in this case. Since records of the trial court have already been received, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2. Any amicus present in the court?
Yeah.
What is your name?
Yes,
Khatan, your lordship.
Accordingly, Miss S. Khatania is Miss Sangeeta Khatania, whose name appears in the list of amicus curiae prepared by the registry, is hereby appointed to defend the cause of the respondent number 2 in this case. The appellant shall furnish copy of memo of appeal along with annexures to the newly appointed amicus curiae. The registry shall reflect the name of Ms. Sangeeta Khatunia as amicus curiae for respondent number 2 in the cause list henceforth. List this matter 20 July for hearing.
22.
For hearing,
I may be heard,
huh?
I may be heard. I is pending there.
IA for suspension of sentence as well as for bail.
In case of acquittal also, I may be heard.
Let the LCO receive.
We'll hear the finally.
Yes, lordship.
Okay, we will not mention. Let it
Let it
fixed on 21 July. On that day, if we may hear I also.
Item 29.
May it please your lordship, lordship may kindly pass over the matter for the time being, lordship. Obliged.
Item 30.
Kindly see the last order dated 28/4/26.
Your lordship, as per office note dated 21/05/2026, no fresh steps has been taken for the issuance of notice upon respondent number 2.
Yes.
Lordship, respondent number 2 at the residential address with to find.
So, who is respondent number 2?
Devo Datta,
What is this case?
crossing of the FIR.
Alleging what? What is the allegation? (120B409).
As well as the charge sheet, lordship. We're taking cognizance in external interpretation from the proceedings.
Why respondent number 2 has been made a party? And court record I scan go.
It's a financial transaction between the petitioner and the respondent.
Yes, what is the submission? Yes, Miss Bora.
Lordship. Still, Lordship, no fresh steps has been taken, but let them let him, direction may be given to take fresh steps on respondent number 2. Lordship.
In the address which is already there, you
Lordship,
take one.
one more chance may be given.
We could not find the residential address of the resident.
Where is the FIR?
Lordship, it starts from 61. 16, Lordship. And translated version is, starts from page 18, Lordship. And relevant page is 19.
Who is the informant?
Informant is Lordship Ankur Sharma. In lieu of sanctioning a loan amount of rupees 30.34 lakhs, Lordship, the informant has deposited an amount of rupees 1,34,000 on the account of the present petitioner, Lordship. Later on also 10,000.
Third Miss, what is her name? S.R. Das, learned counsel for the petitioner. Also Miss S.H. Bora, learned additional public prosecutor. It appears the learned counsel for the petitioner submits that the petitioner is unable to find the residential address of the respondent number 2 and hence could not take steps for issuance of notice upon the said respondent. Stop. On perusal of the record, it appears that said respondent, who is the informant of this case, had filed the FIR not in his personal capacity, but in his official capacity as an inquiry officer while he was acting as deputy. He was posted as Deputy Superintendent of Police, CID Assam. Hence, he need not to be notified in this case about pendency of this case and hence continue. Hence, the notice to respondent number 2 in this case is waived. Let this matter be listed for admission. Next, you present your case on the next day. Since the scanned copy of the trial court records have been received, this matter is ready for hearing. List this matter for hearing on 21st July.
Item 29.
20.
Wait, Mr. Lord. Lord, the service of notice upon respondent number is not complete now. However, my lord, there is an order of this honorable court.
Respondent number?
2, my lord, is the informant.
What is the case?
Yes, my lord, the offense is 420 and 468, my lord. The allegation against me that I have, my lord, assured the informant that a loan has been.
Okay, what happened in service of?
Service, my lord, the notice is answered. As per office note dated
2/3/2016.
2/3/2026, my lord.
Unserved notice in respect of respondent number 2 has been received back without postal remarks.
You take fresh steps.
I'll take, you know, only, my lord, I have a prayer to make, you know. The proceedings in the court below is going on. And the investigating agency has submitted charge sheet. There are 3 numbers, 3 names have been, my lord, implicated in the FIR. Charge sheet has been filed only against me, showing as an absconder. Lord. So, my lord, the proceeding is going on. And my lord, by order dated 15/12/2025, this honorable court was of the view that upon receipt of the TCR, my lord, my interim prayer may be considered, my lord. My case is very limited, my lord, because 420/468, my lord. So far as 468, my lord, there is no material at all, my lord. That I have.
You can agitate this before the trial court.
My lord, I have come for quashment, my lord, of the proceeding, because I have to, my lord, attend, proceeding is at Dhemaji, my lord. And I am a resident of Gauhati, my lord. And
Then we have to examine that issue.
Yes.
my lord, only law point, my lord, that because, my lord, for constituting an offense under 420, my lord, at the very inception, my lord, I have the intention to deceive, and my lord, my.
No, but these things are to be proved in trial.
My lord. Because.
In a 4/528 application,
My lord.
we will not go into the merit or demerit of.
I get prayer, my lord, at this case, my lord. If there is material against me, my lord, at 420 and 468, my lord, then I have no case, my lord. If there is, my lord, if there is no material, because only delivery of property will not constitute an offense under section 420, my lord. My lord,
Let the service be completed first, lordship. I have to go through the TCR
Yes,
also.
lord. My case is dishonest inducement, my lord, which is the sine qua non for constituting an offense under.
No,
section.
but that is to be considered by the trial court, not by this court.
Yes, my lord.
Otherwise, we'll be sitting on trial.
My lordship is correct, but my prayer, my lord, is limited to the extent whether if there is any material, then my lord, definitely I'll have to, my lord, go to the trial court, my lord. But whether it will be an, my lord, abuse of the process of the law, my lord, because that very ingredient, my lord, dishonest inducement is, my lord, not present in the FIR as well as in the charge sheet, my lord. So that is my case. So my prayer, my lord, let the informant appear, my lord.
Let him
Because
appear
let it,
first.
let this, my lord, proceeding be not one-sided, my lord. Let the informant also get a
Let him
chance.
appear.
But my lord, at the returnable date, my lord, the
Lordship, I'm
proceeding may
objecting at
kindly
this
be,
stage.
my lord, stayed, my lord.
Already cognizance has been taken, lordship, under section 419, 420.
Yes, stay is a, without hearing the informant or without.
Because, my lord.
Let him appear, lordship, thereafter, lordship may
till the,
consider,
after
after hearing both
filing
the
of this
parties.
case, my lord, already I have been.
When is the next date fixed?
23rd June.
Lordship may
23rd.
fix prior to 23rd June. Any date.
But my lord, the case is of Dhemaji, my lord. So whether the process will be complete, my lord. Only till returnable date, my lord, if possible.
Once we give that interim relief without hearing other side, we'll never see back in this case again for so many
So many
years.
years. That is what right now happening.
Then, my lord, then,
We will try to dispose of this matter on the next day.
Prayer then, my lord,
Yes.
that circumstances,
My personal appearance, considering dependency of this case, we considered, my lord, on the
You-
next date, my lord.
Yes, that prayer you
That
can.
can be.
My lord.
Heard Mr. M.K. Das, learned counsel for the petitioner.
My lord.
Also heard Miss S.H. Bora, learned additional public prosecutor. The office note, on perusal of the office note dated
2/3/2026.
2/3/2026, it appears that the notices sent to respondent number 2 by speed post have returned without service and without any postal remarks. Stop. In view of the same, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order returnable on. No, after July, 22nd July. Learned counsel for the petitioner has submitted that the petitioner has impugned the charge sheet filed against him in PR case number 18/2025 without there being any materials against the present petitioner under the sections, under the provisions in which, under which the case has been filed. Hence, he submits that the next date of the aforesaid case is fixed before the trial court on
22nd June,
20.
23rd June, 2026.
23rd June 2026.
My lord. 6.
He prays that this court will give direction or you will go before the trial court.
My lord, if I go, then I have to, my lord.
Okay. And hence he prays for dispensing with the personal appearance of the petitioner before the trial court only for the next date fixed. That is 17th of June. 23rd June, the prayer is allowed. The personal appearance of the petitioner before the trial court in PRC case number 18/2025 is dispensed with. Let a copy of this order be sent to the Court of London, Additional Chief Judicial Magistrate Dhemaji by the registry of this court. Let this matter be listed again on 22nd July.
42.
As per officials, dated 13/5/2027, answer.
Unserved notice in respect of respondent number 2, lordship, that has been received by registry. There is no such person in the remarks column.
35.
As per office note dated 20/05/2020.
What is the appeal for? IF4?
I
I have suspension and condition under
Appeal how?
petition.
I is for,
I for suspension of
what is the offense?
10 of the
10 of the POX Act. Heard Miss J.
S.
S. Katoniar, learned counsel for the applicant/appellant. Also heard Miss S.H. Bora, learned additional public prosecutor. On perusal of the office note dated 25/2026, it appears that unserved notice sent to respondent number 2 has been received back with an endorsement within inverted comma, no such person, inverted comma close. In view of the above, this court is inclined to appoint one amicus curiae or to defend the cause of respondent number 2 in this appeal. Accordingly, Ms. Preeti Das, whose name appears in the list of amicus curiae prepared by registry of this court, is hereby appointed as amicus curiae in this case. The appellant shall furnish a copy of interlocutory application as well as memo of appeal along with annexures to the newly appointed amicus curiae. The registry shall reflect the name of Ms. Preeti Das as amicus curiae for respondent number 2 in the cause list henceforth. Let this matter be listed 22nd July.
LCR may be called for, TCR.
The trial court records shall be requisitioned and shall be called for. The registry shall take steps for requisitioning the trial court records. Yes.
My lord, pursuant to the court's direction, my lord, there is a paper book prepared, my lord. We have to receive, my lord, the paper book.
Appeal from
As per office code dated, my lord, 35/2026.
What is the method?
See that. It's under section 10 of PROCEED lawsuit, with a conviction of 5 years lawsuit,
How many days you are behind the bar?
7 months lawsuit, 8 months.
Going through the evidence, my lord, some part, my lord. It's, my lord, cannot, perhaps, my lord, subject to correction will not be a case of, my lord, suspension, my lord, at this stage. Lordships, unto here, my lord, I can point out, my lord.
We'll hear the appeal because paper book is ready. We can hear the appeal
Lordship, yes.
instead of I will give a fixed date for
Before vacation lawsuit.
no before vacation it will be difficult. Or we'll dispose of the IA.
Lordship, for IA lordship is next date maybe, next week lordship date maybe.
Okay. In the meanwhile, heard Mr. M. Hussain, learned counsel for the appellant / applicant. Also heard Mr. MP Goswami, learned additional public prosecutor, as well as Mr. J.C. Bora appearing for respondent number 2. It appears that paper book in the appeal has been prepared by the registry. Let a copy of the same be furnished to the appellant and the learned counsel for all the parties.
Where receipt.
Learned counsel for respondent number 2. The connected interlocutory application may be listed for hearing on 21st, no, before vacation then. 22nd June. List accordingly. Common order management.
Item 34.
May I appear, Madam? May I appear, Madam?
Yes.
So this is Lordship, the appeal was admitted, Lordship, and the records were called for Lordship. And he was convicted under section 307, Lordship, for 4 years, Lordship, and fine of rupees 10,000. I have filed an IA, Lordship, for suspension of Lordship sentence, Lordship. Kindly that may be considered, Lordship.
Wait, please, your Lordship. Lordship, I'm appearing for the respondent number 2 on behalf of M. Sharma. Lordship, we have not received the copies yet.
Piece of interlocutory application. You furnish the copies.
File, Lord.
Heard Mr. A.M.S. Majumdar, the learned counsel for the appellant/applicant. Also heard Mr. K. Bashir, learned additional public prosecutor, as well as Mr.
A. Hussain,
A. Hussain, appearing for
M. Sharma.
M. Sharma, learned counsel for respondent number 2, who submits that he has not yet received the copy of interlocutory application as well as memo of appeal. The appellant is directed to furnish the same to the learned counsel for respondent number 2 within
Today, by
during
tomorrow I'll
within 2 days from the date of this order. Let this matter be listed again on when?
any date in the next week.
20 July,
Kindly, Lordship, next week, Lordship.
next week. And be before vacation day. 22nd June.
Right.
Yes.
Item 45.
As per office note, service to the respondent number 2 is completed. And TCR has already received. Like today I am praying for taking up this matter IA for this suspension of sentence and for granting bail.
Who is respondent number 2?
Respondent number 2 is the informant. As per official process, service is completed, notice sir.
Though my lord, the sentence is my lord below 10 years, my lord, 8 years, my lord. But the conviction under 302 is also there, my lord, in this matter.
304 part 1.
302.
No, 304 part 1.
So 302.
304 part 1. 8 years conviction. 304 part 1, rate with section.
Want to file a written objection?
No, my lord, we don't want to file written objection, my lord, as because my lord below 10 years. The only thing is that, my lord, I need some time, my lord, go through the my lord PCR. Any date may be fixed, my lord. So
And whether the service is complete.
Perhaps lordship in this case, paper book will be required. Because some vernacular SMS vernacular is there, very difficult to lordship to ascertain.
that will be my lord required. Otherwise, my lord, this is sentence order dated my lord 24 to 2026, my.
Then we will direct the preparation of paper book. In appeal, heard Mr. M. Khan, learned counsel for the appellants. Also heard Mr. K. Bushaw, learned additional public prosecutor. On perusal of office note dated 1/6/2026, it appears that the notice issued to respondent number 2. Who is respondent number 2?
Informant.
Victim
No, victim died,
or victim died.
his brother.
Notice to respondent number 2 has been duly served. So considering the nature of the offense involved in this case, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Any amicus present in the court? Accordingly, Miss suggestion.
63, G and C.
Accordingly, Mr. Dipankar Kumar Bagchi is appointed as amicus curiae in this case to defend the cause of respondent number 2 in this case. The appellant is directed to furnish the copy of memo of appeal as well as interlocutory application to the newly appointed amicus curiae. The registry shall reflect the name of Mr. D. Bagchi in the cause list as amicus curiae representing respondent number 2. The registry is directed to prepare the paper book and list this matter after preparation of paper book. And give a date. 28 July. To 8.
Item 36.
I am for the incoming between, I have filed a written objection to the IA matter that was not the reporting. I have filed 1/6 minutes.
What is the offense?
Lordship, Lordship, punishment is 7 years and under sections 304 part 2 IPC Lordship.
304 part 2.
Lordship.
Moreover, another enhancement, I have prepared the cross appeal matter for enhancement his punishment matter.
Where is that?
Yes, my lord. That is also admitted by your lordships and fixed on 25 matter. Both the matter may have.
Should be tagged together.
Yes, my lord.
Lordship, Lordship, in that
Instead
case,
of IA matter.
Lordship, in that case, Lordship, one acquitted accused is there and another accused is present petitioner. So Lordship, the notice.
You have challenged the acquittal also.
Acquittal also and enhancement of punishment.
So that some issue is there, Lordship, whether that appeal is one appeal, whether maintainable or not, Lordship. So Lordship.
That is to be examined.
Or against acquittal
Yes.
and against
Enhancement.
Enhancement of.
that we will examine.
Yes.
Lordship, that's why Lordship.
No, first we will direct the registry to place the matter before together.
Yes.
Otherwise, we don't have records of one case.
Lordship, in that case, Lordship, notice is still not served. So Lordship, so that's why I'm
Can
saying.
you see the order?
No, let him submit.
So that's why my submission is the Lordship. In that case, some time is required. As first notice served, then Lordship, it will be tagged. Otherwise, Lordship.
No, we will tag together and thereafter we'll pass whatever order is required. That maintainability question, you have already appeared.
Lordship.
You can raise that question.
Lordship, in that case, Lordship, another respondent is there. There is.
Even without his appearance, if you raise you can satisfy the court that appeal is not maintainable. We'll deal with it accordingly.
Lordship, my submission is very limited, Lordship. Lordship, in the both appeal is need some more time. And in my IA, Lordship, I have just prima facie one point I am going to showing before this.
But he is here before enhance.
302, I will be deprived. If he acquitted later on 302 and bail is granted to him, he will be absconder. How it is possible to rearrest him?
Heard, Mr. This is item number,
36.
36.
heard Mr. I Hawk. I Hawk,
Lordship.
learned counsel for the appellant / applicant. Also heard Mr. K. Bushaw, learned additional public prosecutor, as well as Mr. R. Islam, appearing for respondent number 2. Stop. Who submits that the respondent number 2 has filed another appeal in respect of this same judgment which has been impugned in this appeal, challenging the acquittal of one of the accused and inadequacy of sentence to the present appellant. And hence he submits that since both the appeals arise out of the same judgment, both the appeals may be taken up together. The prayer is allowed. Let this matter be listed on 25th of June along with criminal appeal number 186/2026.
Lordship, my submission is that, Lordship, my IA may be considered, Lordship.
On that day, we'll consider your eye.
Lordship, as because, Lordship, what I am trying to submit, Lordship, in my IA, since from the day of the first hearing, I've annexed all the evidences and I try to satisfy with the whole dishonorable court, so that my case is very prima facie. That conviction.
The interlocutory application number 236/2026 shall be considered on the next date fixed.
Highlights.
This one item 3 and 4.
Yes.
Chief, item number 2 is a company, your lordship, which is running a IMFL bonded warehouse. And 3 and 4, your lordship, you're the director of the company, your lordship. Now, your lordship, all 3 cases arises from the same assessment order. So what has happened, your lordship, is that we have filed our returns for the year 2015-16, your lordship, with an income of, your lordship, 8,01,508. Now it went for assessment, your lordship, and the AO, your lordship, he came to a conclusion that we are a retail outlet and calculated the income as 7% of the turnover, your lordship. And an assessment order was passed stating that our income is 35,66,191. Now, your lordship, we went in appeal before the CIT appeals, stating that there's a wrong calculation. And also, your lordship, that certain documents which were said that we did not upload it, we had given it by hand, your lordship. Now, in CIT appeal, your lordship gave us partial relief, stating that this is not the interest should be 2%. It should be 2.33% and not 7%. But since we did not get complete, your lordship, relief, we went to the Income Tax Appellate Tribunal, Kolkata. And Kolkata remanded back the entire matter to the learned AOA to reassess it afresh. In the meantime, your lordship, based on the first assessment order, a complaint case was filed, your lordship. And thereafter, your lordship, we have come across this honorable court, and your lordship has stated.
Complaint case alleging what?
Alleging that the false documents, it is at page 20, you're saying, that we evaded tax and we submitted certain false statement.
Okay.
Now, your lordship, that's why we came for quashing of those cases. Lordship has stayed in the other two items, the proceedings in the lower court. Now,
In this case,
this case, item
in all the three cases,
two cases, your lordship. The two cases, the your lordship has already stated. Otherwise, it's similar, your lordship. Even item 2, 3, and 4, all are similar. From the same.
who is the company? If one is the company.
2 is the company. And 3 and 4 are the director.
Why three separate cases are filed?
We came to learn about the cases subsequently, your lordship.
There are three separate cases.
3 separate cases. So they filed one against the company, which is item 2. Then another against one of the directors, Vijay Pangsu, and another Sanju Pangsu.
And this case is this present item number 2.
Yes, present item number 2. Otherwise, assessment order, it is, all the cases arises from the same assessment order. Assessment year 2016-17, financial 15-16. Now what has happened since the fresh assessment, the ITAT has passed the fresh assessment for sent remanded back to learned AO. Learned AO has done the reassessment and a fresh assessment order has been passed, which we have annexed your lordship in the additional affidavit, your lordship. Holding that it should not be 35 lakhs. It is around 11 lakhs, your lordship. Now, the department, respondent authority was supposed to file an affidavit. They took time. They were supposed to take instruction. Because when the first assessment order is already gone, your lordship, the foundation of the case is gone, your lordship. And in the fresh assessment order, your lordship, there was some penalty imposed of 10,000 that we have paid. The challan is also included. And second aspect, your lordship, in fact, our money is there. Our TCS money of more than 4 lakh is pending there. So, your lordship, now the instruction has to be taken by the respondent authority, your lordship.
Regarding what? Regarding your objection.
Regarding your lordship, because since the fresh assessment has been issued, the first assessment order is already, your lordship, there's no foundation to it anymore. Your lordship will kindly come to the new assessment order. That is that I have annexed in my additional affidavit. Page number 6.
Page number?
Page number, internal page 6, your lordship, fresh the new assessment order. Lordship, that will clarify the entire position. I have filed an additional affidavit, your lordship.
There is no additional affidavit there. No additional affidavit is there, but pagination is continuation.
So there's some mistake in that definition. Internal page,
6 is the internal page 6 is the affidavit.
lordship, then the next page, your lordship. I will come to the next page. There is an assessment order 24/3/2022.
Yes.
Lordship have it. If I may just read from the first paragraph. In this case, the SSC filed its return of income for the AY 2016-17 on 17/10/2016, admitting a total income of rupees 8,01,508. The case was scrutinized and assessment order under section 144 of the Income Tax Act 1961 was passed on 21/12/2018 by the assessing officer, determining the income of the SSC at rupees 35,66,191, being 7% of turnover of the business of the SSC of rupees 5,9,45,586. The SSC filed appeal before the Learned Commission of Income Tax Appeal Tribunal against the assessment order. The Learned Commission of Income Tax Appeal has passed the order on 28/2/2020, restricting the net profit margin 2.33% of the turnover of the SSC. This was the first intervention. The SSC filed appeal before the Honorable Income Tax Appellate Tribunal, Kolkata Bench, SMC Gauhati, against the order of the Learned CITA. The Honorable ITAT Kolkata, by its order number so and so, dated 18/3/21, has restored the matter to the file of the Learned AO to decide the issue afresh, your lordship. This is the new assessment order. The entire case, your lordship, is based on the earlier order.
No, where That his complaint was based on the earlier assessment orders.
Yes, lordship will kindly come to the complaint. That is at annexure A, page 18 here. Page number 18.
80.
18, your lordship, of her petition. Annexure A.
Yes.
Lordship will see your Flamingo Brewery. Lordship will kindly come to serial number, page 19, para 2, your lordship.
Page 19 para?
Second paragraph.
Yes.
The SSA's file its return of income for the AY 2016-17 on 17/10/2017, declaring total income at rupees 8,01,508. The case was selected for scrutiny and assessment under section 144, 143, within bracket 3 of the Income Tax Act 1961. Was hereinafter referred to as Act, was completed on 21/12/2018, determining the taxable income of rupees 35,66,191 against declared income of rupees 8,01,508. So lordship will note that assessment year 2016-17. Thereafter, your lordship, this is a complaint. What will kindly come to para 6, your lordship. That is the allegation that in view of the above, the Commissioner Income Tax so and so satisfied and of the opinion that SEC has made willful attempt to evade tax under the provisions of the Act, and accordingly is liable to be prosecuted under 276D, 277 for false statement and verification of return of income filed under the Act, and failure to produce accounts and document willful by not complying with the statutory notices and served on him. Thereafter, after filing your lordship, cognizance was taken that it is at page 28.
No, what it has to do with the first assessment order?
Yes, now your lordship will come to the first assessment order, that is at page 29. Annexure C. So their case is on the basis of the first assessment order, that is at page 29, Annexure C.
Yes.
Lordship, the first para, the SSCs furnish its return of income for AY 2016-17 on 17/10/2016, disclosing an income of rupees 8,01,508. So lordship will kindly take note. The complaint is based on this assessment year, 2016-17, based on this assessment. Now the finding is on the next page, page 30, your lordship. Will kindly take the third last para. Third last paragraph. In view of the discrepancies in figures of the balance sheet and profit and loss account with that of the notes on financial statement, as mentioned in the show cause notice reproduced above, I reject the books of account of the SSC under section 145 within bracket 3 of the Income Tax Act 1961 and proceed to assess the income of the SSC under section 144 of the Act. Sri Ramniwas Agarwal, proprietor of so-and-so enterprise, is a distributor of IMFL SSCs in this charge. Turnover of Mohit Enterprise during so-and-so is 33.65 crore and net profit is 1.88 crore. Thus, Mohit Enterprise has disclosed a net profit percentage rate of 5.6%. Messrs. Flamingo Breweries Private Limited is a retailer of IMFL. So this was the first mistake they have done in the assessment. They considered as a retailer of IMFL, we are actually a bonded warehouse. Having turnover of rupees 5 crore, 9,45,000.
You are not a retailer.
No, your lordship. We are a bonded warehouse. So that is why we went against this order.
You are a bonded
Warehouse.
warehouse.
So basically, your lordship, the IMFL from the manufacturer come to the bonded warehouse. And from the bond, we have our designated area. From there, your IMFL shops, they take it after paying excise duty from the bonded warehouse.
Okay.
Now, the AO considered us as an IMFL retailer, your lordship. And that's why our percentage was considered as 7%. So this is
7% is what? Net profit margin.
7% of the turnover. So our profit was considered as 7% of the turnover.
Okay.
Which came to your lordship 35,66,191. So based on this assessment order, the complaint case was filed before the learned court below. Whereas we challenged this assessment order before the Commissioner of Income Tax Appeals. CIT appeal said it should be 2.33%. We further went to the ITET Kolkata. ITET Kolkata remanded the entire matter back, Your Lordship, to the learned AO again and to look it afresh. Thereafter, Your Lordship, which I was relying on in the additional affidavit, the fresh assessment order has been passed. And Your Lordship, the fine was of 10,000. We have already paid. The challan is also annexed. In fact, we have to get some refund. So, Your Lordship, at this stage, the respondent authorities, they were supposed to file an affidavit, get
Yes.
instruction and file affidavit.
Lordship, actually, this brief was earlier handled by Mr. S.C.K.R. I have been recently allotted with this brief. Though, and in this brief, I have recently.
No, what is the status of this complaint case?
Yes, Lordship. With this regard, I am telling. This complaint case is fixed in the lower court as at the stage of necessary order, Lordship. This has been going on and
Then we'll stay that.
Lordship, with this regard, may I make a submission?
Yes.
The instant complaint case, Lordship, in this case, Your Lordship, is not on the basis of what the assessment is. It is on the basis of what was the conduct of the party at the time of the assessment. Kindly peruse the complaint.
Yes, the allegation is non-furnishing wrong documents, answer.
Non-furnishing of the documents as well as non-compliance with the notices under section 142 and providing false information under verification by way of returns. These were the allegations, and those two allegations still stand, Your Lordship, because you may kindly peruse my complaint petition in para number 3, that the page number 19.
Then these three criminal petition may be heard for final disposal without you are intending to file a written objections.
Earlier, Lordship, but recently I've come to know that an additional affidavit was filed, which has not come to me. I don't have the
copy of the additional affidavit. I have served earlier also. Your
Earlier,
Lordship.
perhaps.
And based on, and Your Lordship, the two matters are already stayed from the same assessment order.
Two matters, that is
The other two connected matters, Your Lordship.
item number 3 and 4.
Against the directors. That is already stayed.
Because
And
it
in
has
the
already
lower
been
court below
decided by
also
the
that has
apex
been-
court, Your Lordship, that if only a reassessment is been directed, in that is not a good case where the prosecution is required to be caused. For the reason that in the proceeding under Income Tax Act regarding the assessment, they puts upon the fiscal liability upon the assessee. Whereas on the other hand, the prosecution which has been initiated by the department before the criminal courts, those are completely on the punitive side. So this has been an established law, Lordship.
Lordship, that part, that was raised in the CIT appeal. That is at page 39, Your Lordship. After that, the CIT appeals passed order. And we went to ITET Calcutta, and the entire matter was remanded back. So
And
when the first assessment
and
order
that
is already
remanded
gone,
back-
and
The
And the
Income
remanded back
Tax
has also been.
Appellate Tribunal is concerned only with your fiscal liability. That is right. The complaint case pending before the trial court will decide whether there is any violation of whether any offense under section 276D or 277 has been committed or not.
And that remanded back thing, Lordship, because that has also been established. The case which was remanded back by the Honorable ITAT, that has also been established.
But connected two cases have already been stayed.
Those were stayed beforehand. Those were stayed beforehand, because before the assessment order was passed.
so Lordship.
The reassessment order was passed.
Let the respondent authority file their response. They have taken more than 2 years to file their response.
2 years.
2 years, Your Lordship.
I'm not known to that, Lordship, because I've recently, just 5 days back,
Let them file their response and Lordship thereafter.
Because I was
take it
about-
for hearing.
I was about to file a additional affidavit, affidavit in opposition, provided I did not know that the additional affidavit is filed.
Heard. Heard Mr. V. Rajkwa, learned counsel for the petitioners. Also heard Mr.
J. Chopra.
J. Chopra, learned counsel for the Income Tax Department, who submits that he has been newly engaged by the Income Tax Department in this case, and therefore he prays for some more time to file. Will you be filing any?
So I may be given a copy of that additional affidavit. I will inform the court whether I would need it.
Even earlier, you
No,
compete
we
against
are
that.
fixing it for hearing next day.
Worship.
Who submits that he has not, your predecessor has not handed over the copy to you.
The additional affidavit.
Okay. He submits that he has not yet received the copy of the additional affidavit filed by the petitioner, and prays for the same. The learned counsel for the petitioner is requested to furnish a copy of the additional affidavit filed by the petitioner in this case to the learned counsel for the Income Tax Department. Income Tax Department by within a period of 2 days from the date of this order. Learned counsel for the petitioner has further submitted that the instant criminal petition has been filed by the petitioners praying for quashing of the CR case number 1103C/2019, which has been filed by the Income Tax Department on the basis of assessment order dated 21/12/2018. He submits that the present petitioner have challenged that assessment order before the Commissioner of Income Tax, and thereafter they have further challenged it before the Income Tax Appellate Tribunal, Kolkata, which has remanded the matter back to the assessing officer who passed the said assessment order. He further submits that now, after the remand of the case, the assessment order, a fresh assessment order has been passed for the assessment year 2016 and 2017. He therefore submits that since the basis of filing of complaint no longer remains, the complaint case is required to be quashed. He submits that in respect of the same assessment order, 2 separate cases were filed by the Income Tax Department. Complaint case were filed by the Income Tax Department, which were challenged by the director of present company. Sanju Fangso and Vijay Fangso are directors.
Yes, sir.
Directors of the present petitioner company in criminal petition number 165/2022 and 168/2022. He submits that in the said case, Putul 165, Jikuno eta dio. He further submits that in the said cases, in both the criminal petitions by order dated 24/11/2022, the further proceeding of complaint cases filed by the Income Tax Department have been stayed during the pendency of the said criminal petitions. He therefore submits that since the instant criminal petition also, the complaint case which has been challenged arose out of the same assessment order, the further proceeding of CR case number 1103C/2019 be stayed during the pendency of the present criminal petition. Stop. He submits that more so due to the fact that the Income Tax Department has failed to file written objection for last 2 years in this case. On the other hand, Mr. Chopra, learned counsel for the Income Tax Department, has submitted that the said assessment order is the order passed by the Income Tax Appellate Tribunal, Calcutta, in the appeals filed by the present petitioner against the assessment orders take into consideration only of the fiscal liability of the petitioners, whereas the complaint case filed by the petitioners, filed by the Income Tax Department against the present petitioners, alleges willful evading of taxes and what?
Non-cooperation, non-compliance.
Non-compliance and non-compliance of the provisions of Income Tax Act and non-cooperation with the assessment officer during the process of the assessment. Hence, he prays not to stay the matter. Sub. I have considered the submissions made by both sides. Since all these 3 criminal petitions are all pending in this court since the year 2022, same needs to be heard expeditiously. Hence, let this criminal petition, let these common order at let these criminal petitions be listed for final hearing on 28th July. In the meanwhile, considering the fact that in connected criminal petition number 165/2022 and 168/2022, further proceeding of the connected criminal cases have been stayed, in the instant case also, during the pendency of this criminal petition, further proceeding of CR case number 1103C/2019 shall remain stayed. List accordingly.
My name may kindly be reflected in.
Name of Mr.
J. Chopra.
J. Chopra be reflected in the cause list as engaged counsel for the Income Tax Departments henceforth.
Okay.
Item 6.
Yes.
What's the date?
Have you filed any affair? Lost your brief where? In the chamber or? Yeah.
Shifting.
So what is your prayer? Heard Miss
B.R. Burman on behalf.
Miss
of
B.R. Burman appearing on behalf of Miss G. Bora, who submits that she has misplaced the brief of this case and therefore seeks some time to trace it out. Stop. None has appeared for the respondent on respondent number 1 on call. You have furnished the copy. You have to furnish the copies of the considering the submissions made by learned counsel for the petition and the prayer is allowed. Let this matter be listed. 20 July.
May I please the Lord? This forcing petition is directed against the washing away searching. Notice was issued against the respondent number 2, the informant. He has already appeared and he has filed his objection, my lord. What when in this case, my lord, the accused, he has borrowed some money from the informant, my lord. And that amount, initially he failed to repay the amount, and because of that, the FIR was lost against the accused, my lord. So, Lordship may kindly turn to page 20, my lord, that is the FIR, my lord. Already the money has been returned by the accused, my lord. There is no dispute pending between the accused and informant, my lord, as of now, my lord.
Informant has appeared.
Yes.
What is your stand?
Lordship, the amount obtained from me by means of shipping, as the FIR prima facie disclosed the ingredients of shipping, because there is no any civil relationship between the accused and the informant. Kindly see the Lordship FIR.
Now, whether the money has been repaid back.
Yes. When he was arrested on 15 February.
Okay, you are opposing his prayer for quashing.
Yes, Lordship, my simple submission is that he will get ample opportunity during trial. So trial let be done.
Yes, Mr. Rashik.
Yes, my lord. Then can you hear the entire matter, my lord?
Oh, yeah.
Already they have filed their NOC, my lord. They have executed 2 agreements and they have.
My NOC part was.
No, not in this manner.
Yes.
Are we going to hear the matter finally today?
Well, I am ready, my lord.
You are also ready. Then start.
But also, can you turn to the FIR, my lord, which is Annexer 2, my lord.
Page number?
Page number, it starts from page 18. The original FIR is at page 20, my lord. The vernacular one, my lord.
Yes.
Got it?
Yes.
Page 20, my lord. May
Yes.
বিনীত নিবেদন এই যে মই চতিয়াৰ এগৰাকী হোটেল ব্যৱসায়ী বিগত 3 মাহমান পূৰ্বে মোৰ হোটেল গুণগুণত বহিৰাজ্যৰ 2জন যুৱক কেইবাবাৰ অহা যোৱা হৈছিল নিজকে কাপাডিয়া গ্ৰুপ কোম্পানীৰ প্ৰতিনিধি বুলি পৰিচয় প্ৰদান কৰাৰ লগতে চতিয়া অঞ্চলত কোম্পানীৰ ফেক্টৰী স্থাপনৰ বাবে ভূমিৰ প্ৰয়োজনৰ কথা সদৰি কৰিছিল বহিৰাজ্যৰ যুৱক সুৰজভান সিং ভণ্ডাৰীৰ কথামতে মই মোৰ পৰিয়ালৰ 25 বিঘা ভূমি প্ৰদানৰ বাবে সাজু হৈ 6 কোটি টকাৰ মৌখিকভাৱে বন্দবস্ত কৰি ভূমি পৰিদৰ্শন কৰিছিল ইয়াৰ পিছত গুৱাহাটীৰ দুখন বিলাসী হোটেলত কাপাডিয়া গ্ৰুপ কোম্পানীৰ স্বত্বাধিকাৰী বুলি পৰিচয় কৰাই দিয়া ৰাহুল কাপাডিয়াক পৰিচয় কৰি দিছিল প্ৰথমবাৰ গুৱাহাটীৰ এয়াৰপৰ্টৰ সমীপৰ হোটেল প্ৰেমলিন আৰু দ্বিতীয়বাৰ ৰেডিসন গ্ৰুপ ৰাহুল কাপাডিয়াৰ লগত সাক্ষাৎ কৰাইছিল য'ত ৰাহুল কাপাডিয়াৰ লগত আছিল কেইবাজনো বডি দেহৰক্ষী হোটেলত ৰাহুল কাপাটি আৰু সুৰজ ভান সিং ভাণ্ডাৰীৰ মাজত এক পাশা খেলৰ দৰে খেল আৰম্ভ হৈছিল আৰু এটা সময়ত সুৰজ ভান সিং ভাণ্ডাৰী খেলত 90 লাখ টকা পৰাজয় অৰ্থাৎ হাৰি সেই টকা পৰিশোধৰ বাবে মোৰ পৰা 15 লাখ টকা ধাৰলৈ বিচাৰে ময়ো আগন্তুক ভূমি বিক্ৰীৰ কথাৰ বাবে 3 দিনৰ ভিতৰত সুৰজ ভান সিং ভাণ্ডাৰীক 15 লাখ টকা প্ৰদান কৰোঁ ইয়াৰ পিছৰ পৰা সুৰজ ভান সিং ভাণ্ডাৰীৰ লগত যোগাযোগ কৰিও আজিৰ প্ৰতি মোৰ ধাৰে লোৱা 15 লাখ টকা ঘূৰাই পোৱা নাই আৰু মোৰ লগত সুৰজ ভান সিং ভাণ্ডাৰীৰ পুনৰ যোগাযোগ নোহোৱা হ'ল গতিকে এই বিষয়ত মহোদয়ে অৱগত কৰিলো আৰু বহিৰাজ্যৰ প্ৰবঞ্চক যুৱক সুৰজ ভান সিং ভাণ্ডাৰীৰ ওপৰত
No, why loan was given?
Actually, what happened, Milord, they were about to purchase one land from the informant, Milord. They wanted to set up one factory in around Sotia area, and because of that, they wanted to purchase 25 bighas of land from the informant, Milord. And the person on whose behalf this Suraj Singh Bhandari is the accused, he was acting on behalf of one Kapadia group of companies. The company wanted to set up one factory there, Milord. And this informant, he came to Gauhati to get himself introduced with the owner of the factory company, Milord. And during that meeting, there was some kind of it's a kind of board game, Milord, in which he gambling, Milord. He lost 90 lakhs to the owner of the company, Milord. And so that informant was also there. So in order to recover that, he took loan of 15 lakhs from the informant, Milord. That was in December 2024, Milord. But thereafter, that amount was given by the informant in cash, Milord. Thereafter, he failed to return that money immediately. In fact, Milord, that 50 lakhs was also lost, Milord, in the gambling, Milord. So he failed to return the money. So your lordship will, thereafter the case was registered, Milord. The FIR was lost on 5/2/2025, Milord. It was given to the SP, and thereafter the SP forwarded the FIR to the Sophia police station. And subsequently on 14/2/2025, it was registered, Milord. The FIR was registered under section 111(3).
What is 111?
That is, Milord,
BNS.
organized crime, Milord. Punishment is 5 years to up to life. It may goes up to life and plus fine of 5 lakhs, Milord. And 318(2) and 316(2), Milord.
18 is?
18 is sitting, Milord.
And 16(2) is?
And 316 is the breach of trust.
Breach of trust.
Thereafter, Milord, the accused, he was arrested, Milord. On 15/2/2025, he was arrested. Then, Milord, after his arrest, your lordship will kindly turn
15/5?
15/2, Milord. 15th of February 2025. He was arrested. Your lordship will kindly turn to page 24, Milord. That is the first agreement executed between the informant and brother of the accused, Milord. Annexure 4, page 24, Milord.
Page 24.
Yes, Milord.
Yes.
Relevant portion is the your lordship will kindly turn to page.
What is this agreement?
This is the agreement by which a part of the amount was already returned, and there was a balance portion of 6,50,000, which was they took time for 50 days to repay the amount. Your lordship will kindly turn to the main paragraph after the first cycle, page 25. The last paragraph.
Yeah.
Whereas Suraj Van Singh Bhandari, son of Meherban Singh Bhandari, residing at so and so, that is the present second part, is the brother of the Binod Singh. Binod Singh is the executant of the agreement on behalf of Suraj Van Singh Bhandari, Milord. Present second party and Suraj Van Singh Bhandari had taken a loan of 15 lakhs only to the first, that is from Bharat Hazarika on 8/12/2024. And he promised to return the aforesaid loan amount within 1 month from the date of receiving the aforesaid loan amount. And Suraj Van Singh Bhandari has already paid a sum of 8,50,000, Milord, out of the total amount of 15 lakhs, Milord. So on 15/2/2025, they have already executed one agreement by which the informant, he has already said that already 8,50,000 has been returned earlier. Only 6,50,000 has been remained to be paid, my lord. This agreement is notarized, my lord. Before the notary public at Biswanath Charili, my lord, at his place, my lord.
On which day FIR was lodged?
FIR was lodged on 5/2, my lord. It was the FIR
Before
lodged
this agreement.
before the SP, my lord. The SP has forwarded the FIR to the OC. He has forwarded the letter FIR on 7/2/2025, and the OC has received it on 14 as per
No,
it was-
FIR was lodged on 5/2.
5/2, my lord.
And
Before the
when you were
official, my lord.
arrested?
It was registered on 14.
No, when you were arrested?
He was arrested on 15/2, my lord.
15/2.
Yes, my lord.
That is the day when the agreement was.
That is the day on which the agreement was executed, my lord. The agreement was executed between the brother of the accused and the informant himself, my lord. The Bharat Hazarika, he is the informant, my lord. And he has admitted that he has already received 8,50,000, my lord,
Okay.
on that day. Only
mean-
6,50,000 has been remained to be paid, left to be paid, my lord.
Remaining amount?
And they have stated that on the next page, page 26. You'll also may kindly turn to page 26, my lord.
Yes.
The first paragraph, top paragraph. And whereas the second party has approached to the first party to give 15 days time to return the aforesaid remaining amount 6,50,000, my lord. And the first party already agreed to accept the proposal of the second party. Though the amount was supposed to be paid within 15 days, my lord, but ultimately it was paid after 1 month, my lord. They ought to have paid it on 1st of March, but it was paid on 15th of March, my lord. Your lordship will kindly turn to the second agreement, which was executed on 15th of March. That is Annexure 6, page 32, my lord. Even on the day on which the agreement FIR was lost, it was not that the entire 15 lakhs was supposed to be paid, my lord. Only 6,50,000 has been left to be paid, my lord. Because he had already earlier received 8,50,000, my lord. That has been edited by him, my lord, in the agreement.
Yes.
That is also this second agreement is also notarized, my lord. It was executed on 15/3/2025, my lord. And your lordship will kindly turn to page 34, my lord. The clauses.
Yes. What is this?
That mutual agreement shall be effective on and from 15/3/2025. That the second party shall pay the balance amount of 6,50,000 only today. That the first party shall not interfere in any dispute between me and Suraj Bhan Singh Bandari, and also no objection for granting bail by the Honorable High Court against him. The second clause number 4, that the second party has cleared all the liability and has paid the total amount of 15 lakhs, shall not be liable to pay the amount to the any amount to the first party as aforesaid. The wide agreement serial number so and so dated 15 to, that is the earlier agreement. They are referring to the earlier agreement. Stamp number so and so, notarized by so and so, has also will also be a part of the agreement, this agreement, my lord. And on 15/3/2025, my lord, the remaining
No, this agreement was executed on 15/4.
this 15/3, my lord.
But you read that date.
The date is on top. This agreement is made on the 15th day of March
But
2025.
again, you read before signatures of the parties. Next page, 33. In witnesses whereof.
No, my lord, they have written it wrongly, my lord. It should be because it was notarized on 15/3/2025, my lord. The notary signature and seal is here, my lord.
Yes. So that date is wrongly mentioned.
Yes, date is wrongly mentioned, my lord.
A month is wrongly mentioned.
Yes, my lord. And after this amount, 6,50,000 has been paid. Thereafter, means they in the bail application which was pending before the Honorable High Court, will also kindly turn to Annexure 7, my lord. That is the order passed by the Honorable High Court while granting bail. my lord.
Page number?
At page number 35, Annexure 7. It starts from page number 35.
Yes.
You will also kindly turn to page 36. the last, it starts from the para number 4, last para. The learned counsel for the petitioner further submitted that the petitioner has been languishing in judicial custody for 38 days since his arrest in 14 to 2025. And considering the matter in its entirety, as well as the nature of the offense, petitioner may be enlarged on bail. Then next para, Mr. Pathak, learned counsel for the informant, submits that the entire amount has been paid by the accused petitioner to the informant, and the informant has no business if the bail is granted to the petitioner, my lord. On the other hand, Ms. So-and-so, learned additional public prosecutor has submitted that she has no objection if the prisoner is released on bail. After they have filed their, given their NOC, my lord, he was released on bail, my lord. Now the entire amount has been paid. There is no dispute between the informant and the accused, my lord. And they have used the criminal case as a leverage to retrieve the money only, my lord. To settle the dispute, civil dispute, my lord. Already the amount has been recovered and amount has been paid. Now they are again pressing the for the where is the intention of sitting, my lord? The intention ought to have been right from the beginning, my lord. The intention was not there, my lord, to see. He has lost some money in some gambling, my lord, and he because of that he couldn't pay the amount, my lord. Though he was supposed to return it within 1 month, but it took him more than 3 months to return the money. And on the day on which the FIR was lost, my lord, already part of the amount has been refunded back, my lord. And in fact, that has not been reflected in the FIR also, my lord. But the
No,
agreement,
FIR was lodged on 5th of
February.
it was registered on
February.
14 only, my lord, 14/2. The FIR was given to the SP, my lord. SP has forwarded it to the OC, my lord, and ultimately it was registered on 14/2, my lord. And he was detained on 14/2 itself. And thereafter means the informant, he has admitted that already a part of the amount has already been paid, my lord. It is already reflected in the first agreement itself, my lord.
And second agreement?
And the second agreement, the remaining amount was paid, and after that, the second agreement was executed, my lord.
Okay, okay. Anything else?
So there is, as of now, there is no dispute, and as you all also knows that the decision of the Supreme Court that criminal case should not be used as a leverage for recovery of the money. They've used that for recovery of the balance amount, my lord, and already that amount has been paid. So there is no dispute between the parties, my lord. So my humble submission is that with the person, he is from Uttar Pradesh, my lord. Now they are just trying to harass him, my lord.
Yes.
So the search should be closed at this stage, my lord. There's no humble submission, my lord. And if you also go on, then I can place the decision of the Supreme Court also.
Which-
There, and I don't think that will be required. And if you also says that, then I'll produce it before you.
You are not ready today.
No, I can supply all the this.
Okay, yes. Mr. Goswami,
Now that whether the search sheet has been submitted, madam. So these arguments can be made before at the time of filing of charge.
no, but apparently it appears from the FIR that there was a civil dispute. He took loan and he failed to repay back. No other allegation apart from that has been made. And that has been paid also after some time. So where is the criminal wrong? Yes,
Are they need to be paid?
yes.
Worship, I have already got my money, but the issue is whether the recovery of money which was obtained by means of criminal wrong.
No, no, like we have to decide whether is it a criminal wrong. You, in your FIR,
Yes.
have only alleged that he took loan to repay the money which he lost in gambling.
Yes.
And he failed to repay back that money. Nothing apart from that.
Yes.
So
Okay.
where is that?
He took loan, but
And
he did not pay me.
and had his intention
Yes, that is the to see
when the charge sheet has been filed.
a charge sheet has been filed on
And what is the date of charge sheet?
Page 29.
27/6/20
Page 30?
39.
the search was, the date appears on 30/4/2025, but cognizance was taken on July, my lord. 2nd of,
No, but much before the filing of charge sheet, much earlier than the date of filing of charge sheet, you had repaid back the money.
yes, my lord. And they have executed the two agreements also, that he will have no grievances against the accused, my lord. When, my lord, Sarset doesn't disclose any criminal wrongdoing, my lord.
Yes,
Lordship,
you have the charge sheet. Wait.
charge sheet has been filed after due
It is
investigation.
annexed there, my lord. Annexure 8, my lord.
Please read page 42. Page
42.
42.
Yes, Lordship.
Last para, read it loudly.
Last para, Lordship.
Last para.
The prosecution of the case is that on 11/2/25, a written petition has been received through the Honorable Office of the Superintendent of Police, Bishwanath, white memo number so and so dated 7/2/25, submitted by the complainant, namely Shri Bharat Hazarika, so and so, so and so, so and so, to the effect that at about 3 months ago, two young men from outside state, namely Suraj Bhan Singh Bhandari and Lucky Singh, so and so, were several times came to the Gungun Hotel of the complainant. They introduced themselves as a Kapadia Group company's representative and said that land was needed for setting up a factory of the said company in the area of Sotia. Accordingly, the complainant was ready to hand over 25 bighas of land which was in the name of his family, and inspected the land after making an oral settlement of rupees 6 crore with Suraj Bhan Singh Bhandari and Bhandari, a young man from outside state. Thereafter, Suraj Bhan Singh Bhandari introduced the complainant with one person, namely Rahul Kapadia, who introduced himself as the owner of Kapadia Group Company at two luxury hotels in Gauhati. Suraj Bhan Singh Bhandari introduced the complainant first time in the hotel Kremlin near the Gauhati airport, and second time at the hotel Radisson Blue with Rahul Kapadia, where there are many security guards around the Rahul Kapadia. At the hotel, a Pakha game-like game was started between Rahul Kapadia and Suraj Bhan Singh Bhandari, and the said game once a time Suraj Bhan Singh Bhandari had lost about 90 lakhs, and he asked the complainant to lend him 15 lakhs to recover his lost money. Then the complainant given rupees 15 lakhs to Suraj Bhan Singh Bhandari within 3 days for the purpose of forthcoming land sale. The complainant communicated to Suraj Bhan Singh Bhandari, but he did not return 15 lakhs. Now Suraj Bhan Singh Bhandari had stopped communication with the complainant over phone. On receipt of the written petition, SI so-and-so Probin Bay has been endorsed to inquire the matter, and after finding sufficient ground During the inquiry, a case has been registered on 14/2/25. White Sotia PS case number so and so under section 111(3), 318(2), 316(2 of BNS and investigated into. So,
Next page.
Next,
What investigation was?
yeah,
Page 43.
43.
Yes.
During the investigation, the PO visited a rough sketch map of it was drawn with index and examined the
What is the PO?
PO place of occurrence, Lordship.
Where was the place of occurrence?
During the investigation, the place of occurrence was visited. This sentence should be like that, Lordship. During the investigation, the place of occurrence was visited. Rough sketch map of it was drawn with index and examined the complainant as well as available witnesses and recorded their statement under section 180 BNSS in connection with the case. During the examination,
Where the FIR was lodged, before which?
FIR was lodged at Sotia PS.
Sotia. And gambling was done at Radisson Blue.
Radisson Blue, Gauhati.
So Sotia IO came to Radisson Blue.
They ought to have, as per their charge sheet, Lordship.
Okay.
So, Lordship, my
No, read completely to find out what they have
yes.
found.
May I continue, Lordship?
Yes.
It is could reveals that 3 months ago, 2 young men from outside state, namely Suraj Bhan Singh Bhandari and Lucky Singh, were several times came to the Gungun Hotel of the complainant. They introduced themselves as Kapadia Group Company's representatives and said that land was needed for setting up a factory of the said company in the area of Sotia. Accordingly, the complainant was ready to hand over 25 bighas of land which was in the name of his family and inspected the land after making an oral settlement of 6 crore with Suraj Bhan Singh Bhandari. After few days, the arrested accused person asked the complainant to lend him 15 lakhs cash money. Then the complainant given 15 lakhs to Suraj Bhan Singh Bhandari within 3 days for the purpose of forthcoming land sale. Then the arrested accused person had stopped communication with the complainant and he did not return the land money till death. During investigation, the cousin of the accused person, namely Vinod Singh, was arrived at PS and submitted a court affidavit agreement copy regarding land money and recorded his statement under section 180 BNSS. During the course of investigation, the accused person has been recorded his statement under section 180 BNSS and also medically examined them at SDCH Vishwanath Chariali by government doctor. Accordingly, sufficient evidence were found against the accused person, namely Shri Suraj Bhan Singh Bhandari, son of so and so, so and so, so and so, and he was arrested and forwarded to judicial custody after found sufficient evidence against him. Under the above facts and circumstances, a prima facie case has been found well established. 318(2), 316(2 of BNSS against accused person Shri Suraj Bhan Singh Bhandari, son of so and so. Hence, charge sheet submitted against him to face the trial. Therefore, I pray before your honorable court to kindly prosecute him under the above mentioned section of law. On the other hand, the other accused is
What is the date of submission of charge sheet?
yes, Lordship.
Date of submission of charge sheet.
Date of submission of charge sheet is 1/12/25.
26/2025.
Huh? Yes, before that,
Let's say.
26, 2025.
34. Final report. Oh, yes, Lordship. At page 39, Lordship, second para. 34/25. Page 39. Para number 2.
Okay, now what is this?
So, Lordship, I am going to sell my land. Why should I have to pay loan to the accused? Because they plotted a drama in my humble understanding, they plotted a drama to obtain money. They came from outside state and they took money, and thereafter for 2-3 months they did not communicate with me. So ingredients of cheating is very much there. Now my humble submission is that when at the moment the accused Suraj Singh Bhandari was arrested, his relatives came to his rescue. They executed this agreement. They assured me to return my money which was obtained by cheating. Obviously, my intention is to get my hard-earned money. I did that agreement. They returned my money. But the question is whether the money which was obtained by means of cheating and subsequently recovered can absolve the criminal liability on the part of the accused. My understanding is no, because he has to face the trial. He will get ample opportunity during trial. If in the trial he can prove his innocence, he will be acquitted.
Why you paid him the money?
Lordship, I paid as per my affair. They plotted a drama in her
No,
hotel.
where is that statement?
Yes, Lordship, in the affair, Lordship. May I read the affair, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই চতিয়াৰ এগৰাকী হোটেল ব্যৱসায়ী বিগত 3 মাহমান পূৰ্বে মোৰ হোটেল গুণগুণত বহিৰাজ্যৰ 2 যুৱকৰ কেইবাবাৰো আহা হৈছিল। নিজকে কাপাডিয়া গ্ৰুপ কোম্পানীৰ প্ৰতিনিধি বুলি পৰিচয় প্ৰদান কৰাৰ লগতে চতিয়া অঞ্চলত কোম্পানীৰ ফেক্টৰী স্থাপনৰ বাবে ভূমিৰ প্ৰয়োজনৰ কথা সদৰি কৰিছিল। বহিৰাজ্যৰ যুৱক সুৰজ সিং ভাণ্ডাৰীৰ কথা মতে মই মোৰ পৰিয়ালৰ 25 বিঘা ভূমি প্ৰদানৰ বাবে সাজু হৈ 6 কোটি টকাৰ মৌখিকভাৱে বন্দবস্ত কৰি ভূমি পৰিদৰ্শন কৰিছিল। ইয়াৰ পাছত গুৱাহাটীৰ দুখন বিলাসী হোটেলত কাপাডিয়া গ্ৰুপ কোম্পানীৰ স্বত্বাধিকাৰী বুলি পৰিচয় কৰাই দিয়া ৰাহুল কাপাডিয়া পৰিচয় কৰি দিছিল। প্ৰথমবাৰ গুৱাহাটীৰ এয়াৰপোৰ্টৰ সমীপৰ হোটেল প্ৰেমলিন আৰু দ্বিতীয়বাৰ ৰেডিসন ব্লুত ৰাহুল কাপাডিয়াৰ লগত সাক্ষাৎ কৰিছিল, য'ত ৰাহুল কাপাডিয়াৰ লগত আছিল কেইবাজনো দেহৰক্ষী। হোটেলত ৰাহুল কাপাডিয়া আৰু সুৰজ সিং ভাণ্ডাৰীৰ মাজত এক পাশা খেলৰ দৰে খেল আৰম্ভ হৈছিল আৰু এটা সময়ত সুৰজ সিং ভাণ্ডাৰীয়ে খেলত 90 লাখ টকা পৰাজয়।
So it only says that there was a gambling.
Yes.
Why you paid money? Who asked you to?
Lordship,
You gave only loan to him with and obtained a promise that it will be returned back.
yes. Lordship, at that time, what happened, Lordship? They plotted a drama.
Where is that statement that they plotted a drama?
Because I had to sell my land. There was some communication during that period. Then
there was some gambling between Rahul Kapadia and the present accused. He lost money. He requested me that, so I have to. So,
Heard Mr. R. Dwara,
R. Sekhar.
Raj Shekhar Dwara. No, R. Shekhar only.
Yes,
R. Shekhar. This is item number?
item 10.
R. Shekhar, learned counsel for the petitioner. Also Mr. M.P. Goswami, learned additional public prosecutor, as well as Mr. M. Pathak, appearing for respondent number 2. This criminal petition has been registered on filing an application, on filing a petition under section 528 of BNSS by the petitioner Shri Suraj Bhan Singh Bhandari, praying for washing of the charge sheet filed in Sutia PS case number 17/2025, as well as the proceedings of PRC case number 158/2025, which is pending in the Court of London, Judicial Magistrate First Class Vishwanath Charali, under section 111 within bracket 3/318 within bracket 2/316 within bracket 2 of BNS 2023. What is the status of the trial now?
So, it's
Any-
paid, my lord. Notice has been
Yes.
issued. He has received the notice, but that has been issued by his now.
The facts relevant for consideration of the instant criminal petition, in brief, are that on Five two 2025, one Bharat Hazarika, within bracket respondent number 2 herein, had lodged an FIR before the officer in charge of Vishwanath Sarali Police Station, inter alia, alleging that that 2 months prior to filing of the FIR, 2 men from outside state came to his hotel and introduced themselves as representative of Kapadia Group, and also informed him that they are looking for a suitable land for setting up factory of their company in Sutia area. Stop. The said youth identified themselves as Suraj Bhan Singh Bhandari, within bracket present petitioner, and one Lucky Singh. Stop. It is further stated in the FIR that the first informant was willing to provide 25 bighas of land for the project of the for 25 bighas of land which was in the name of his wife for the aforesaid purpose, and also made an oral agreement to sell the land to Suraj Bhan Singh for a consideration amount of 6 crores. Thereafter, it is alleged in the FIR that the present petitioner introduced the first informant to one Rahul Kapadia, who introduced himself as the owner of the Kapadia Group company. This was done at two luxury hotels in Gauhati. Stop. It is further alleged in the FIR that in the hotel, Radisson Blue at Gauhati, the present petitioner lost about 90 lakhs, about rupees 90 lakhs in gambling and he requested the informant to lend him 15 lakh rupees so that he can recover the lost money. And accordingly, the first informant gave him the money, gave him the said money. As he was hoping the sale of his land to the petitioners. Stop. With an assurance that he will repay back the said money within 3 days. Stop. However, it is alleged that thereafter the petitioner did not return the said money and he stopped communicating with the informant. Accordingly, the FIR has been lodged. Mr. R. Shekhar, the learned counsel for the petitioner has submitted that the FIR or the charge sheet does not disclose any ingredient of offenses under section 111.
Within bracket 3 में लो.
111 within bracket 3 slash 318 within bracket 2 slash 316 within bracket 2 of BNS 2023. He submits that this is a simple and pure case of the petitioner failing to repay the loan within the time agreed between the parties. He, however, submits that the loan of 15,000, 15 lakhs taken by the petitioner from the first informant has already been repaid back, and two agreement to that effect have also been executed by the respondent number 2 within bracket first informant on 15/2/2025 and 15/3/2025 respectively. He submits that copy of the said loan application as copy of said agreement indicating repayment of loan to the respondent number 2 are annexed along with this criminal petition. He submits that this is a case where attempt to criminalize a civil dispute has been made by the respondent number 2 only with a view to pressurize the respondent number 2 to repay the loan at the earliest. He submits that now, since no outstanding due is there to be paid to the respondent number 2, the continuation of criminal case pending against the present petitioner would be an abuse of the process of court. He submits that this is a fit case where inherent jurisdiction of this court under section 528 of BNSS may be invoked to quash the proceedings of PRC case number
158 of the
PR case number 158/2025 pending in the court of Judicial Magistrate First Class Vishwanath Sarili. Stop. Mr. MP Goswami, learned additional public prosecutor, though fairly submits that on perusal of the FIR, it appears that the dispute between the parties are civil in nature. However, he submits that since the charge sheet has been filed, the petitioner may appear before the trial court and may agitate the matter before the trial court. Hence, he opposes the quashing of the PRC case number. On the other hand, Mr. M. Pathak, the learned counsel for the respondent number 2, has fairly submitted that the respondent number 2 has received the loan amount which was given to the present petitioner. Stop. However, he submits that since an offense under what provision?
318
318
2.
within bracket 2, that is the offense of cheating has been committed in this case. This is not a fit case for quashing of the proceeding of the PRC case number so and so, number the he submits that the petitioner was deceived by he submits that the respondent number 2 was deceived by the petitioner to part with the money by playing a drama in the Radisson Blue Hotel, and he parted with the money only with a hope that his land would be purchased by the petitioner. However, same was not done, and as such, this is a clear case of cheating within the meaning of section 318 within bracket 2/2 of BNSS 2023. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. On bare perusal of the affair, it appears that it narrated two separate incidents. One relates to the promise, one relates to the agreement which was entered into between the petitioner, one relates to alleged oral agreement which was entered into between the petitioner and respondent number 2 regarding sale of their land regarding sale of the land at a consideration amount of rupees 6 crore. Stop. And the second part of FIR is second part of FIR narrates a story narrates some facts which reveals that at Hotel Radisson Blue, the petitioner indulged in gambling and after losing 90 lakhs in gambling, he asked for 15 lakhs of rupees 15 lakhs as loan to recover from 15 lakhs loan from the respondent number 2 to recover his lost money with a promise to repay the same back within 3 days. However,
Not 3 days, my lord, 1 month. My lord.
where is that 1 month?
That's there in the FIR itself. That amount was paid in within 3 days, my lord.
Oh no, where is that 1 month recovery?
It was that is in the agreement, my lord. First agreement. Page 25, my lord.
Okay, sorry.
In the last para.
Line to cut off. Last line cut off. And accordingly, the respondent number 2 lent the said money to the petitioner within 3 days. However, same was not repaid back. Thus, on bare perusal of the affair, it appears that it is a simple from failure of the petitioner to repay back the loan of 15 days of rupees 15 lakhs to the respondent number 2 within the stipulated period, within the agreed period. However, it also appears that thereafter the said amount has been repaid back, and to that effect 2 agreements were executed by the respondent number 2, that is on 15 February 2025 as well as on 15 February 2025, acknowledging the receipt of rupees 8,50,000 against the said loan, and the next agreement on 15th March 2025, acknowledging the receipt of balance loan amount. Stop. It appears that the charge sheet in this case has been filed on 30/4/2025, bearing charge sheet number 35/25, dated 30/4/2025. Stop. Thus, the charge sheet has been filed after repayment of the loan amount, and in narration to the said fact has also been made in the charge sheet itself. Under such circumstances, this appears to be a case of belated repayment of loan by the present petitioner to the respondent number 2, and nothing more than that. Stop. No ingredients of section 318 slash 318 within bracket 2 slash 316 within bracket 2 of BNSS are revealed either from the charge sheet, either from the FIR or from the charge sheet. Hence, this court is of considered opinion that continuation of the criminal proceeding in PRC case number
158 of
158 oblique 2025 pending before the Court of Learned Judicial Magistrate First Class Vishwanath Charali would be an abuse of process of court, and as such, this is a fit case to invoke its inherent jurisdiction by this court to quash the proceedings of PRC case number 158/2025, which in this court accordingly does. Stop. Next paragraph. This criminal petition is accordingly allowed. The proceeding of PRC case number 158/2025 are hereby quashed.
What's up?
Item 11.
My please, Your Honor. The application is filed for crossing of an FIR matter. The petitioner before your lordship, my lord, it was a additional XP matter. And your lordship take up the FIR page 15, my lord.
What is the status?
My lord,
Pending investigation.
And nothing is there, my lord. If your lordship sees the FIR, no case has been made out, my lord. Unless, without any justification, I was arrested, my lord.
Now, has it been stayed? No.
Because there is nothing to investigate, so they have just dragging the matter, man. Even no cognizable offense has been made out.
Yes, what is the submission?
My CD was called for, but my lord, we didn't receive the CD.
CD would be necessary.
But there is a CD, if your lordship goes to the FIR, that is.
But we have to peruse the case then.
I understand.
Okay. Tell me about what is there in the FIR.
Page 17 is the FIR, my lord. It states, it starts with a letter from the, I beg to state that DVAC, Director of Vigilance and Anti-Corruption, received a letter from the AP headquarters and closing a government letter with a report of SP regarding various allegations against the petitioner. That regarding bringing the assets of the so-and-so under ambit of investigation. And does the cause of verification in this regard? So there is a verification report submitted. Again, I have gone through the government letter with enclosures. As per the content of the report submitted by SP, during the morning hours, a video conference was held by the Assam Police Headquarters directing all the districts to conduct a special drive against the illegal slaughter of cattle and sale of beef obtained from such illegal slaughter. Subsequently, the SP Hojai held a telephonic conversation with all gazetted officers, Hojai agency, and assigned the responsibility among the gazetted officers under the disposal. The petitioner was
was additional SP Hojai, was assigned the responsibility of Hojai police station. Drive was smoothly executed. 8 persons from Doboka PS, 3 persons from Hojai PS were apprehended. Later, rumors were spread out in Nilbagan area related to release of one of the apprehended persons. As per his direction, I in charge Nilbagan Petrol Expo submitted a report on 2/7/2025 in this regard. As the allegations were serious in nature involving a public servant, SP Hojai physically visited Nilbagan PP and Hojai PS. During his visit, he revealed that on 1/7/2025, SI Pranab Soika of Nilbagan Outpost conducted a raid at Masum Hotel for selling beef under supervision of the petitioner. During the raid, 7 kg of suspected beef was seized, and as per the instruction of the petitioner, the one Javed Ahmed in charge of the hotel was apprehended and taken to Hojai police station around 12:30 AM on that day. The petitioner also reached the Hojai police station, sat in the OC's room. Thereafter, one Rafikuddin, the owner of the hotel, and one Soidur Rahman, middleman, made the petitioner to secure his release of Javed Ahmed. Then it is SP demanded rupees 2 lakhs from the release of the Javed Ahmed, indicating the amount in two finger gesture. After a brief discussion, the apprehended person named Javed Ahmed was released. Later on, the said Rafikuddin and Saidur Rahman visited the residence of the petitioner behind the Hojai police station and handed over rupees 50,000 in cash. During the examination of Rafikuddin, Saidur Rahman both admitted to the fact that Rafikuddin handed over 50,000 to Pallab Tamil so and so, and in his official residence 17 CCTV footage of the OC corroborated the statement of Saidur Rahman. Now this you will also find, according to why he was released, because the report of the state veterinary dispensary, my lord, it was stated that it was a goat mill. That is annexure 2, my lord. It was a goat and one was found.
No, acquisition is not that.
Yes, fine.
Acquisition is your demanded
Yes.
bribe.
So, yes, I understand. And two of these persons, my lord, they have sworn in affidavit, my lord. You'll also may kindly see the page 21.
What affidavit?
Affidavit they have sworn, my lord. One is by my Rafikuddin, my lord. He says that page 21, my lord.
Yes.
That detained person so and so was my nephew, was released on basis of veterinary officer certified that his meat was chicken, not a beef, and offered. I have no reason to offer bribe to so and so. But after my release, his meat remained in the police custody. So we asked the officer in charge to release the meat. And since it was found to be goat and boiler chicken, and when the officer told us that he forwarded a matter and instructed us to meet the petitioner to request the release, so we was a senior officer handling this. So I went to his residence and visited solely for purpose of requesting a formal release of the seized meat. And doing no money was a king. That is, two of these Rafikuddin similar statement was made by.
No, why this affidavit has been shown?
No, actually they say that this SP, my lord, on next page you will also may kindly see.
No, I am wondering why this affidavit has been
To
shown.
nullify the fact that we've never made any statement.
When an investigation is going on,
Understand, but
they could have given statement before the IO.
but IO did not record the statement, man. IO never recorded a statement, man. Because the SP has asked him to make a statement.
That we will find from this case deck.
And secondly, your lordship may kindly see, when they did not find anything against me so far as this section, because section 7, your lordship first of all demand.
Who lost the affair?
It is Deputy Superintendent of Police, Directorate of Vigilance and
Vigilance,
Enforcement.
because first ingredient so far section 7 is concerned, there should be a demand, then thereafter there should be acceptance. The demand, the person from whom that demand, they have designated that there was no demand. And
No, that will be revealed only from case diary.
understand, my lord, but because here your lordship will kindly see in the FIR itself, the SP says that additional SP even so that he has already made those persons, and those persons had confined it to him. Later said Rafikuddin had visited residence so they according to him he has took the statement of these two witnesses who said that the demand was made. But the witnesses have categorically said that no, the SP has taken to our residence, it kept our confined place and took our statement. That is page 22. On 2nd of July, 10 AM, while I was not a police team led by the senior superintendent police, Saurabh Gupta forcibly took me to the custody from my hotel at Nilbagan and taken to later on to the Hojai. I was kept in illegal detention until 2 AM, and I was slapped and threatened, intimidated, and forced to repeat statement that dictated to me. Under this caution, I was made to false statement implicating Pallab Tamuling. So that is that was that on 4th of June.
Who pressurized?
The SP, man.
So there is a enmity between SP and
Yes,
DSP.
but during the course of it, their statement was never recorded, my lord. The SP come, while SP sending the report, my lord, he has indicated that I have examined these two persons and they have implicated him, implicated the present petition. Now during investigation, no statement has been recorded. This statement of those witnesses were.
Therefore, the case diary would be necessary.
And regarding also the disproportion of income, my lord, that first of all, for disproportion of income also, the first ingredient is that what is the nature of disproportion, my lord? Only one allegation is that there was a one house must, your lordship will find that next subpara as desired by the government that I have conducted a preliminary verification, assess aspect of so and so. Doing it was found that Pallab Damoli has owned a flat in the name of Magnam Nirman at Jonapur, Kailipara. Simply owning a flat doesn't amount to disproportionate. What much is income? What is the hurry? What are the expenditure? What are the savings? After deducting all that, the question of that has been done in a preliminary inquiry itself, man. Not after filing of the FIR, man. At least for purpose of make out a case of cognizable offense, man. But that also was not done.
You are on bail.
No, I was never arrested, man. I was placed under suspension. I filed a repetition challenging the suspension.
You were placed under
Suspension,
suspension.
man.
It is revoked.
No, we have filed an application repetition, my lord. It will come next week, man. No department proceeding.
You are still under suspension.
Still under suspension. No department proceeding. Nothing was there.
Okay, we'll calling for case diary. We are calling for case diary.
Your lordship will fix a date, my lord, because it is a matter of 2025, my lord.
Yes, we'll fix
September
a date.
2025.
Fix a date. Heard Mr. Pallab Kotaki, learned senior counsel assisted by Ms. N. Kashyap, learned counsel for the petitioner. Also heard Mr. K. Bushaw, learned additional public prosecutor, who prays for some more time for production of case diary. Considering the contention raised by learned senior counsel for the petitioner, it appears that perusal of the case diary would be necessary for consideration of the instant criminal petition. Hence, learned additional public prosecutor is requested to produce the case diary on the next date fixed. Let this matter be listed. 20 July.
Last occasion, your lordship, the up-to-date scan copy of the case record was called for.
Up to date?
Up-to-date scan copy of the case record was called for with effect from January 2026 to till date.
Yes.
On that day, I could not say about the status of the case, your lordship, and to know the status of the case on that day, the scan copy of the up-to-date case
Yes.
record was called. But today I got instruction that your lordship, this case is presently pending at appearance stage, your lordship. And herein, your lordship, I have filed this petition, your lordship, to get zimma of cash amount which was seized from the house of the present petitioner. And a petition was preferred before the court below and which was rejected at page 26, your lordship.
This case, a report was called for regarding Jimma of the seized cash from his house.
What is the offense?
The cash was recovered from him and that, as per the investigation, that cash is from the sale proceeds of the narcotic substance. It is
No, in which case the
It is section 21B and 29 NDPS Act.
21B.
Lord, and
You have prayed for Jimma before the trial court?
yes,
Where is the rejection order?
page 26. Page 26. only for money, your lordship. Because from the possession of the petitioner,
Where is the charge sheet?
the sheet I have not annexed, your lordship. Herein, page 21, your lordship.
Yes.
Page 21 is the seizure list, your lordship. Actually, the Alice contrabands were recovered from the other co-accused. And the present petitioner, he has been implicated on the basis of a statement of the co-accused. And the house of the petitioner was searched, and page 21 is the seizure list, your lordship, what are the things they have recovered. The cash money of rupees 2 lakhs and one pan card, and the third one is one black plastic polythene without having anything.
Lordship, kindly say page 20 is the FIR, there it is specifically one. Page 20.
The alias contraband was recovered from the
No, money was suspected to be
yes.
proceed of selling NDPS item.
Yes.
But after, during investigation, what was found? Whether that suspicion was verified or it still remains suspicion. That CD, you go through the charge sheet, because if there is evidence to indicate that this is from proceed of crime, then Jimma will be rejected. But if there is nothing to indicate that this is by selling the contrabands,
Plus,
then he is entitled to get it back.
plus.
You have received you are also one of the accused.
I am the accused, your lordship, but I have been
These were the
implicated on the basis of a statement of the co-accused.
No, maybe, but your charge sheet has been laid against you.
The copy of the charge sheet is not with me.
You have appeared before the trial court or
Yes,
not?
I appeared, your lordship.
You are on bail.
Yes.
You have not yet received the copies under
No.
section.
Because still it is.
We have to find out
Plus.
that this is not from proceed of crime. If there is any indication that this is, because material shows that it is only suspected to be proceedings of crime.
Yes.
Is there anything to substantiate that? You go through.
Yes.
Let him go through.
Friday, your lordship.
Yeah. Okay.
Right.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor, who submits that the money recovered, money which was seized in the connection of the NDPS case number. What is the NDPS case number?
NDPS case number.
Special within bracket NAR case number 56/M within bracket M of 2024, pending before the Court of Learned Special Judge Bangaigaon, was suspected to be proceed of crime, that is by selling narcotic drugs. However, he submits that he needs some time to go through the scanned copy of the trial court records to verify the same before he makes his submission. The prayer is allowed. Let this matter be listed.
8th, my lord.
8th of 8 is
No, Monday. Monday.
okay, 8th of Yeah.
In this case, private respondent has appeared today.
I'm waiting for respondent to.
Your lordship, fix a date for hearing.
Documental.
The measure of 215 BNSS, providing some false evidence in lower trial court.
Yes, Miss Bora. Whether the trial court records have,
Records perhaps not received.
it will be required.
It will require. So in the LPO order.
Heard Mr. What is your name?
This again.
D. Soikel, learned counsel for the appellant. Also heard Miss S.H. Bora, learned additional public prosecutor, as well as Mr. S.K. Lahon, appearing for respondent number 2. It appears that the records of the trial court have not yet been received in this appeal, in this case yet. Hence, issue reminder for trial court records. Registry to take steps for issuance of reminder. Let this matter be listed again on 22nd July.
30 July.
On
30 July.
30 July. Oh, why?
3-0.
Why?
But there is some difficulty with my senior counsel, Mr. N. Bora. Yes, some difficulties.
Okay, okay. 30 July. 30 July.
May I please, Honor? My lord, this matter is before your lordship on the, my lord, limited ground that, my lord, Honorable, my lord, Supreme Court passed, my lordship, you are aware, my lord, the landmark judgment, my lord, Rajnesh versus. my
Now,
lord,
what for this IAs?
Yeah, my lord, passed, is my lord, file, my lord. In the meantime, another order was passed, my lord, to bring, my lord, on record of the trial court, my lord, that order to be passed by this honorable court, my lord. And due to wrong fixation of, my lord, area, my lord, maintenance amount, my lord. I am at this stage, my lord, I am not pressing on this aspect, my lord. I am saying, my lord, this main matter may be remanded, my lord, back for fresh disposal, my lord, as per the guidelines of the Rajnesh, my lord, and Neha and others. Lordship, kindly will look page 57. Page 57, where, my lord, maintenance was only granted 4,000, my lord. I was agreed. An approach to the, my lord, higher forum, my lord, that is learned session judge. Session judge, my lord, remanded back, my lord, for disposal of matter, my lord. Thereafter, without any even application from, my lord, applicant side, my lord, suddenly, my lord, this 4,000, my lord, is increased to, my lord, 8,000, my lord. Again, that lordship, kindly will look page 57.
You are husband or wife?
Husband.
Okay.
Page 57, lordship. Here, lastly, my lord, it is provided considering all these code deem it fit to direct the respondent to pay 4,000. Again, this order, my lord, I approach, my lord, learned session judge, page 58, whereby, my lord, this matter was sent back, my lord.
Why it was sent back?
Because, my lord, this matter was not found, my lord, to be interfered with. Then, my lord, page 62 order. Again, my lord, it was directly, my lord, it was made, my lord, 8,000. Relevant portion, my lord, page 63. After, my lord, first paragraph. As such, after hearing the both sides on prayer of interim maintenance and considering the income of the respondent for the time being, which is shown
by him in the affidavit on assets and liabilities, this court deem it fit to direct the respondent to pay 8,000. And against this 8,000, I also filed, my lord, criminal revision appeal. This is now judgment, my lord, page 74.
This order has been passed in a DV case.
DBK,
Then you preferred an appeal.
appeal.
Where is that?
Appeal page, order page 74 onwards. '77 is the relevant portion, my lord. Situated thus, I dismiss this appeal on contest, no post earlier stay, if any, stands vacated, send down the TCR with a copy of this document.
No, where is the operative part? Which?
77, my lord.
Okay. The appeal was dismissed.
Therefore, I am before your lordship.
Now, what is the wrong in the appellate court order?
Order is wrong, my lord, because, my lord, in the original maintenance, interim maintenance, my lord, suddenly skipped from, my lord, 4,000 to 8,000, my lord, without any appreciation of the materials on records, my lord. It is not decided in this as per the guidelines, my lord. And again, this order, my lord,
What do you do?
when he is a teacher, my lord, contractual teacher, gets salary, my lord, around 36,000. He has, my lord, in the meantime, they are divorced, my lord. I annexed, my lord, divorce. Therefore, my lord, he remarried, my lord.
Now, what is your submission? First of all, on what count the appellate court's order is wrong?
That their income was not, my lord, properly appreciated, my lord.
Okay. Then,
And, my lord, this is, my lord, higher side, my lord, because, my lord, she is, my lord, immediately after marriage, my lord, she deserted the petitioner, my lord, filing one after another case, my lord. And in the meantime, my lord, petitioner before your lordship prepared one, my lord, divorce case, my lord, before the family court signature, and which was allowed, my lord. Ex parte she did not appear, and ex parte it is, my lord, granted. Therefore, my lord, proper, my lord, appreciation of the materials on record is necessary, my lord. My lord, family court's order, my lord, page 50, my lord.
from where the family court comes?
Divorce just to show, my lord, because there is no relation, my lord, and there is no chance of recovery of relation also, my lord. Therefore, just for lordship notice of this aspect, my lord, nothing else. So, my lord, considering, my lord, the guidelines, my lord, and income of both the side, my lord, I am, my lord, also pleading that, my lord, before the trial court, my lord, she is also teacher, private teacher. And highly qualified, she is also, my lord, graduate.
Yes, yes.
My lord, there is no wrong in the order of the trial court, my lord. My friend himself referred the Rajesh Neha case, where the director to consider the affidavit of assent and liabilities of both parties. The learned trial court, my lord, kindly recommend page number 33, the asset and liability affidavit, my lord, of the husband, my lord. The wife is unemployed, my lord, without any source of income. Page number 33 is the affidavit submitted by the husband, my lord. Page number 33, relevant page is page number 38. My friend admitted, my lord, his income is 36,000. Page number 38.
Yes.
My lord, monthly income, F, details of income of the deponent. So it is mentioned in the affidavit, and after going through the affidavit, it is also mentioned in the orders, my lord. And the wife affidavit, my lord, page number 23, my lord. relevant page 26. She has no income. Without any source of income.
Page number?
Page number, my lord, 23, wife's affidavit. Relevant page, my lord, page 26. Page 26, F. Clause F, my lord. She is unemployed. So, my lord, only criteria, only criteria, my lord, only to consider the asset and liabilities while, my lord, determining the my lord, interim maintenance or interim compensation, anything, my lord. So, in the first place, my lord, the honorable trial court had, my lord, directed for payment of 4,000. Against this 4,000, he had, my lord, approached the appellate court. And the appellate court find that without the asset and liabilities affidavit, it was past 4,000. So the matter was remanded back, my lord, in the first instance. And after remanding, my lord, the asset and affidavit filed, asset and liabilities, and thereafter going through the asset and liability affidavit, the learned trial court increased the amount from 5,000 to 8,000 because he has the government employee 36,000 per month. His income was at that time, and on the basis of 36,000, the honorable trial court allowed 8,000 per month. And against that, my lord, the second criminal appeal was filed in the second time, and the honorable appellate court, my lord, rightly, my lord, did not interfere, my lord, going through the same asset and liabilities affidavit. It is mentioned in page number 76, 76, my lord. Learned appellate court mentioned, my lord, page number 76, that his income mentioned, admitted in the affidavit, that it is 36,000. So, my lord, for the present, my lord, in the rising price of the, my lord, day to day, my lord, there is nothing wrong in passing the, in rejecting the appeal, my lord, which was challenged. And more interestingly, my lord, in the, my lord, order was passed in 2022, and he has till date only paid an amount of 95,000 only for last 4 years, my lord. And then arrears amount of about 1,60,000 is, my lord, pending, my lord. He is not paying regularly, my lord, for which she has been, my lord, in severe financial hardship, my lord.
Arrears is of about?
Arrear is more than 1,60,000, my lord, as on date, my lord.
My lord, just my lord, just my lord, learn and friend what said, my lord, in this context, my lord, also, my lord, this judgment, my lord, is mentioned, my lord. That, my lord, the maintenance may not be granted in such a way that, my lord, that should be burden. Paragraph, my lord, 7, short paragraph 77 onwards. Here, my lord, I am running on deficit budget, my lord. In my affidavit, page 34, he needs, my lord, without her maintenance, my lord, needs, my lord, minimum expenditure 37,932, my lord. Without giving her, my lord, 8,000, my lord. Even then, my lord, 4,000 to 8,000 it is imposed.
Where have you mentioned? Where have you mentioned your expenditures?
My lord, page 34, my lord, in my affidavit, my lord.
It is only for not paying the maintenance. Where is the evidence? No document is, my lord.
It is minimum nowadays. He is a teacher, my lord. BA, B.Ed, M.Ed pass. My lord, he is a family, my lord, mother, sister, brother, in a social life, my lord. We are also living in the society, my lord.
No, where is that expenditure?
My lord, page 34, clause 7, my lord, general monthly expenses of the applicant, my lord.
Why 10,000 medical bill?
The entire family, my lord, dependent on him, my lord.
No proof is, my lord, annexed, my lord, regarding this.
I was fighting even, my lord, against 4,000. Suddenly, my lord, made it up.
It is on the basis of affidavit, my lord. Only after perusal of the affidavit.
Where of the source from the affidavit he got to give, my lord,
Okay. Anything else?
My humble prayer is, my lord, considering the present day, my lord, scenario regarding the price hike, my lord, a person cannot survive, my lord, with an amount of less than 8,000, my lord. And the decisions are there, my lord, that the maintenance is to be, my lord, fixed to such an amount that the where the petitioner was living at the time of her husband's house, my lord, the same status she should be maintained, my lord. The husband is earning 36,000 per month, my lord. Then how the wife can survive less than 8,000 amount, my lord, today, including the not the bare necessities, including her medical expenses also may be there, my lord. Travel expenses may be there, my lord. Other expenses may be there. So, my lord, this amount may not be interfered with, my humble submission, my lord. And the area amount may also be directed for payment, my lord, without interfering with this 8,000 amount, my lord.
And immediately, my lord, after marriage, she fled. And rape case was also filed against the brother.
The 498 proceeding is going on, my lord. 498 proceeding is going on, my lord. Where, my lord, the cruelty was there, my lord. It will be proved before the court.
Heard. Reserve. Heard Mr. A. M. Bordwin, the learned counsel for the petitioner. Also heard Mr. A. J. Kadir, learned counsel for the respondent. Hearing concluded, judgment reserved.
I may be allowed one or two citations I will supply.
Yes, if you want to submit written gist of your submission, both of you, both the I'm giving a date. Hearing concluded. However, learned counsel for both the parties are requested to submit the written gist of their argument along with the ruling cited by them on the next date. Release this matter. When will you?
Before vacation, any date.
23rd. 23rd June. Yes.
May I make a mention? Item 37, which did not reach.
Yes, what mentioned?
In the morning, what happened, your lordship? Myself and Mr. S. Waterpo, now senior advocates. We are
Yes.
referring for a respondent number 2 and 3, your lordship. Now, the brief was taken from us earlier, your lordship. So on the last occasion,
Who took the brief?
the respondent number 2 and 3. Your lordship.
And they engaged some new counsel.
I had I have informed them. And I had
27th
a written letter also, your lordship wanted to peruse the letter. On the last occasion, I had brought it to your lordship for this. I informed them also that if they want to engage any other advocate, we have no problem, no issue. And I have taken this NOC from them.
Okay. None has appeared. Who is for the appellant? Oh, you are appearing for the respondent.
And for the respondent number 2 and 3, the private. So basically, they were the complainants, your lordship.
But who filed this criminal petition?
What has happened, your lordship, this 2 and 3, they had initially filed their complaints against the appellants. And the complaint regarding this is that
So none is appearing for the complainant, petitioner.
Lordship, I'm for the petitioner.
Yes. What is the name?
J. Lotha, Lordship.
J. Lotha, heard Mr. J. Lotha, learned counsel for the petitioner. Also heard Mr. V. Rajkua, who submits that he has intimated this court on the last date fixed that brief of this case has been taken back by the respondent number 2 and 3, and he no longer represent respondent number 2 and 3. In this regard, an NOC was also given to who is this Piyush Langtasa?
Pitus Langsa is respondent number 2.
Given to the
And Comac employees 3. Both of them had given the NOC to us, your lordship, when they took the brief.
given to them by the respondent number 2 and 3, indicating that they are withdrawing the case from them and may engage some other counsel. Stop. Under such circumstances, the names of Mr. V. Rajkua and S. Bhattakur and Ajay Sharma is no longer required to be reflected in the cause list, as they are no longer the engaged counsel for the respondent number 2 and 3. Stop. Uparodhibo also Miss S.H. Bora, learned additional public prosecutor for respondent number 1.
Also, Lordship, there is an interim to the extent that the investigation of the subsequent FIR will be stayed, Lordship.
Interim was granted.
Yes, Lordship, there is an interim.
By which date?
During more than 3.
The interim order granted earlier
14/8/2025.
shall remain stayed. Whether case diary has been called for?
That will be required.
Yes.
And also, in the meantime, also, direction may be given to the petitioner to, take steps for the respondent number 2 and 3, because.
No, but it is known to them. They themselves have withdrawn. It is not that they have withdrawn. The certificate issued by respondent number, the NOC issued by respondent number 2 and 3 on 29th April 2026 be marked as X and be kept in this record as a part of it. Let this matter be listed again on 24th July. The interim order shall continue till next date.